Uncharted territory now, so I am greeting everyone, including the media presence. Good morning, everybody.
Morning, Judge.
Morning, Judge.
Morning, Judge.
You have prepared a timetable for me, and I have given an indication that I would like our lunchtime to be shortened a bit, but we can see how it goes in case someone desperately needs an hour and 15 minutes to do something. Did you get my message?
We did. Should we introduce ourselves formally or first?
Yeah, I think you can proceed just to place yourself on the record. I just wanted to deal with the issue of the time first, but in any event, it doesn't matter.
Could we raise
Yes.
that? We've had a discussion.
Right.
If we're going to have a half an hour lunch break, we also have discussed a 20-minute and not a half an hour tea break. And we may be able to finish everything other than our reply today. Does that suit you, Judge?
That sounds in order to me. Right, in that case, yes, in that case, I think the parties can then proceed to introduce themselves for the purposes of the record.
Judge, I'm Peter Hodes. I appear together with Johan de Waal, who's in a different room, and Chris Quinn, who's alongside me. We are for the plaintiff.
Please the court, this is Jeff Budlander. I appear for the respondents and defendants with my learned colleagues Stephen Budlander and Shaista Kazi.
Thank you. So then we have amici. They will be arguing tomorrow, I see. Are they present today?
Yes, Judge. Anton Katz speaking. I'm together with Mr. Michael Bishop, and my attorney is Adela Peterson of Fabridge's Wertheim Becker. All three of us are present virtually, but we're all in different venues.
I see.
And we're for the UCT, the second amicus.
Thank you. And then the someone from CALS. I saw someone here.
She's talking, Loretta,
She's
you're
muted.
You're on mute.
Morning, Judge.
Morning, Judge.
So here you are.
Yes.
Apologies.
Yeah, technology gets to us sometimes. Morning, Judge. My name is Lerato Pasha. I appear with my colleague Lungelo Njangase. We are representing the first amicus, that is the Center for Applied Legal Studies. He's got his hand.
Thank you very much. Thank you very much. Are there any preliminary issues that the parties would like to raise before we start? Anyone?
Judge, may I just raise a procedural matter? We've agreed amongst ourselves that as far as the legal representatives of the parties are concerned, they will all remain on mute and off camera, except when they're speaking. So the only people on camera will be yourself and whichever counsel is speaking at the time. That will assist with the bandwidth.
Thank you very much. Is there anything else before we proceed? Nothing? Advocate Hodes?
Thank you. We are going to try and see if we can finish everything but the reply today, as I indicated to you. Our first general observation, lady, is that the three matters, Riddell, Clark, and Lamini, are not the same for purposes of considering the exceptions to the two special pleas, in the sense that in the Clark and Lamini matters, they do not and clearly cannot contend that their statements are protected by the right to academic freedom. Mr. Duval will deal with the academic freedom aspect, and he will deal with costs, both in greater detail, but for the...
Can I just pause for a moment? Let's see. So you say the Clark and the Lamini matters, they cannot contend for?
I do not contend for reliance on academic freedom. only the 3 Riddell defendants, you'll recall, at the summer school at the University of Cape Town, they are contending for academic freedom and that giving them further rights, which we will, Mr. Duval will discuss with you at the appropriate time. And CALS has in its heads of argument a heading reference to Clark and Dlamini, but they, although it's not of any moment, it should not appear on the CALS heads. Our second general observation, my lady, is that the defendants, that is the Riddell defendants, Clark and Dlamini and Cullinan, have conceded that the exception to the second special plea must be upheld on the basis that this court is bound to apply the judgment of the SCA in SA Taxi. The defendants accordingly accepted that if they want to have the requirements for a juristic person to sue for defamation changed, as they do, they would need to persuade the Constitutional Court to change the law. Nothing accordingly needs to be said about the exception to the second special plea other than it is common cause between the plaintiffs and defendants that it must be upheld. Mr. Duval will argue that costs should follow that result. Although not entirely clear, CALS does not seem to agree that the second exception must be upheld, but it also does not explain how SA Taxi should be distinguished, and it cannot get around the defendant's concession for purposes of this case. We shall deal with any argument that CALS may have in this regard in reply if necessary. That then, milady, leaves the exception to the first special plea for consideration. On this aspect, the defendants ask our courts to take the extraordinary step of closing the doors of the courts on the plaintiffs, thereby denying them their rights in terms of Section 34 of the Constitution without any regard to the merits of plaintiffs' claim. If I may just refer you for the moment to Section 34 of the Constitution under the heading Access to Courts. Everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. That, by way of example, could be by way of arbitration. On this aspect, the positions of the other parties are as follows. The defendants contend, milady, that the first special plea can be accommodated under the existing common law, and more particularly the power of a court to prevent the abuse of its process. Should this not be possible, they contend for a development of the common law either in terms of Section 39(2) or 173 of the Constitution, so that the common law includes the new defense they pleaded. May I mention in passing that this is being recorded as you...
Yes, I'm aware of that. Yes.
This new defense, they say, would be in line with the thinking of other jurisdictions which have put in place protections against what we are known as slap suits, although occasionally CALS refers to them as slap suits, but that's typographical. As an aside, my lady, it should be that by far not all the states in the United States have anti-slap legislation. Not all the provinces of Canada have such legislation. In Australia, only one territory and none of the states have such legislation, and neither New Zealand nor the United Kingdom have such legislation. And we'll come and talk a bit about the First Amendment in the United States. CALS makes no submissions on what the current state of the common law is in relation to the scope of the abuse of process defense, but contends for the development of a slap suit defense. CALS emphasizes in its heads that this new defense sought to be developed is different from an abuse of process defense. In its application to be admitted as an amicus, UCT contended that it wishes to develop a qualified privilege defense for academics in defamation matters. However, this development can obviously not be considered by your ladyship, as it was not pleaded by the defendants themselves, and that would have to be on the pleadings. In its heads of argument, UCT accordingly does not deal with its new defense, but merely argues that the right to academic freedom and freedom of scientific inquiry provided in section 16(1)(d) of the Constitution must be taken into consideration. That's an aspect which my learned friend, Mr. Duval, will deal with, as I've already adverted to. It's convenient to deal first, my lady, with the defendant's contentions and then with those of CALS. Thereafter, we deal with some of the foreign legislation which establishes a slap suit defense. The defendant's main contention is that our courts have recognized that they have the power and indeed the duty to prevent an abuse of their process, and that this duty includes eliminating matters where litigation is pursued for an impermissible motive or purpose. It is important to emphasize at the outset that it is defendant's case that the pursuit of litigation for impermissible motive or purpose on its own constitutes an abuse regardless of the merits of the plaintiff's case. The plaintiff's case, on the other hand, is that outside the context of an abuse of the court's procedures, emphasize procedures, an improper motive or purpose on its own is not a self-standing defense in our law. On the contrary, in terms of recent jurisprudence of the SCA, a substantive legal claim as opposed to the court's procedures can only be regarded as an abuse under common law if the proceedings are unsustainable and are emphasized as a certainty. The difference between the plaintiffs and the defendants on this issue is indeed the crux of the dispute before your ladyship. We rely on the very recent decision of the SCA in Mpanga. Now, do you have, lady, available to you the authorities on which we rely?
Yes, I do. Yes.
Could I ask you to go to page 126 of
Right.
volume 1?
127. Is it 126 or 127?
Sorry,
127.
That's good enough for me, my lady.
Yeah, sure. Yes.
Could I take?
Let me, sorry, so we're on 127?
Yes.
Because I flagged it, yes.
And could I ask you,
Mapanga's case.
and could I ask you to go to paragraph 25?
Right.
Make sure my page numbers are the same.
Yes.
So there's no misunderstanding, my lady. Could I don't get.
I found it.
Can we go to 126 first for a moment? Could we go to 126? I can just make sure that I haven't got my page numbers wrong.
Right.
What do you not have Mpanga, member of Executive Council, etc., Mpanga on the left-hand page on 126?
Sorry. No, I have the heading of the case with the case number on page 127.
127.
So if you take me to paragraph, did you say 25? Then I am on page 139.
139.
Yeah. Or did you say paragraph 25?
130. Paragraph 25, whatever the ladyship's page is, I'm sorry. What is your...
Right, I am on page 1. Sorry, I think there is something probably wrong. If you just see 128. Oh yeah, no, there's nothing wrong with my bundle. Paragraph 25 is, it starts with, it was firmly established in the South African common law. Is that the paragraph you're referring to?
What page does that appear?
139 in my bundle.
Is your bundle a page per page of the judgments or two to the page?
It's page per page. That makes the difference, yeah.
Somebody's given you, my lady,
Yes.
you different.
Yes. But it's in order. You can just refer me to the paragraph. I'm sure I'll find it.
Thank you,
Yes.
my lady. So let me have a look at 25.
Yes.
It was firmly established in the South African common law long before the advent of the Constitution that the Supreme Court had the inherent power to regulate its own process and stop frivolous and vexatious proceedings before it. This power related solely to the proceedings in the Supreme Court and not to proceedings in the inferior courts or other courts or tribunals. The following principles crystallized over the ages. It had to be shown that the respondent had habitually and persistently instituted vexatious legal proceedings without reasonable grounds. Legal proceedings were vexatious and an abuse of the process of court if they were obviously unsustainable as a certainty, I emphasize, and not merely on a preponderance of probability. I may just mention in my learned friends' heads, there is an error where they refer in a quotation to preponderance of possibility. That is incorrect. It's preponderance of probability. I must point out at this juncture that this definition applied to all litigation that amounted to an abuse of court process. The attempt by the MEC's counsel to distinguish the cases from which the principle derives on their facts was therefore mistaken. A court must, in granting this type of relief, proceed very cautiously and only in a clear case make a general order prohibiting proceedings between the same parties on the same cause of action in respect to the same subject matter where there has been repeated and persistent litigation, and craft such order to meet only the immediate requirements of the particular case. The stringent onus on the applicant who seeks the relief and the need for the court's caution, the stringent onus on the applicant who seeks the relief and the need for the court's caution in exercising this power obviously arise from the fact that the relief curtails a litigant's access to court. Let me just bear with me for one moment. I could take you then to paragraph 27, but I'll take you to the last line on the page. The contention made on the MEC's behalf that Cordery was an AD case, you'll see in footnote 16, that Cordery did not attempt to define the limits of the kind of orders that can be granted in terms of a court's inherent powers, or state that other forms of persistent vexatious conduct, such as are present in this case, which resulted in extracurrial as opposed to judicial proceedings, would be excluded, was wrong. The court, I quote, correctly comprehended and applied the principles set out in the matter. It is according of no assistance, my lady, to suggest, as the defendants do in their heads, that the question of improper motive does not appear to have been at issue in the Mpanga matter. They say that in paragraph 28.4. Mpanga defined in terms the scope of the abuse of court process doctrine, insofar as that doctrine can be used as a defense to a substantive claim in law. We now, my lady, turn to deal with the cases relied upon by the defendants for the contention that improper motive or purpose is a self-standing defense in our law. First, they rely on lawyers for human rights, my lady, and that we would find in their heads in paragraph 24, page 10. Lawyers for human rights versus minister in the presidency. They say the Constitutional Court reiterated that courts have the power and indeed a duty to prevent the abuse of their process. But, my lady, that case was concerned with the exception to the BioWatch rule, which ordinarily protects those bringing constitutional cases against government, against adverse cost orders. You know the BioWatch case. In Lawyers for Human Rights, the Constitutional Court merely reiterated that the exception to BioWatch applies to cases which are frivolous or vexatious, or where a litigant had acted from improper motives. This has nothing to do with a defense to a substantive claim. A court obviously has a wide discretion when it comes to cost orders, as is illustrated by Lawyers for Human Rights. In that matter, the Constitutional Court upheld a cost order against the LHR, as the latter took a considerable time to bring an application to set aside certain rates, but then proceeded to set the matter down one day after launching. Such proceedings were not regarded as proper or protected by BioWatch. Secondly, the defendants refer to Bynash versus Wixley. Now I'm starting to get a bit worried. It's our case number 16, and we make the point to you, it's an important case. Muhammad C.J. referred to with approval in Bynash versus Ernst & Young. We make the point that it's apparent from the passages quoted that Bynash concerns an abuse of the court's procedures for a purpose extraneous to their objectives. I'm emphasizing procedures. The abuse of procedures, for instance, by a defendant to delay a matter, is an altogether different topic. It might be that in such instance, the merits are not the only or even the predominant factor to consider. We are, however, in the present instance, not concerned with the abuse of procedures, but with the question of when an abuse of process constitutes a defense to a substantive claim. And you will remember that what was dealt with was the Vexatious Proceedings Act and its constitutionality. Bynash v. Wixley, milady, adds nothing to the debate on the topic. Now, neither do the cases on which Bynash versus Wixley relied. And I want to take you, now, it's our case 16. And I'm worried now about the correct page numbers. If you go to the volume 1, you'll see case number 16, but I don't know. Ours starts on page 81, milady. What's happened here now?
Which case are you referring to now?
Bynash v. Wixley.
Okay. So I have it on page 40.
Page 40, sorry.
Yes.
All right. Can you then go inside the case to page 734 of the actual, of the...
Right, let me see. I'm almost there. Yes, I have it. Yes.
Let me start at
Muhammad CJ, where are you? Yes.
734C.
Yeah.
the merits of the attack on the order setting aside the subpoena.
That's right.
Counsel for the respondent on appeal contended that the issue and service of the impugned subpoena on Wixley in the circumstances of the present case constituted an abuse of the process of court, and that the court au quo was therefore correct in making an order setting aside that subpoena. There can be no doubt that every court is entitled to protect itself and others against an abuse of its process. I emphasize process again. Where it is satisfied that the issue of subpoena in a particular case indeed constitutes an abuse of it is quite entitled to set it aside. As was said by the Villiers J.A. in Hudson v. Hudson and another, when the court finds an attempt made to use for ulterior purposes machinery, please remember machinery, devised for the better administration of justice, it's the duty of the court to prevent such abuse. Now let me just mention to you, Hudson versus Hudson, to which reference is made, concerned the last minute mala fide abuse of the exception procedure to procure a postponement. What does constitute an abuse of the process of the court is a matter which needs to be determined by the circumstances of each case. There can be no all-encompassing definition of the concept of abuse of process. It can be said in general terms, however, that an abuse of process takes place where the procedures, emphasize, permitted by the rules of the court to facilitate the pursuit of the truth are used for a purpose extraneous to that objective, and is referenced inter alia to standard credit. And we make the point to you, my lady, in standard credit, an issue was inter alia whether it was abusive to bring certain claims in the High Court that could have been prosecuted in the Magistrates Court. The full bench found no abuse on the facts. However, had the court found to the contrary and dismissed the matters, nothing would have precluded the plaintiffs from pursuing their claims in the appropriate court. Just bear with me for one moment, please. The third case relied on by the defendants is Phillips versus Buerta. They rely on that in paragraph 29.3 at page 14. In that case, a private prosecution was used to extort money from an accused, my lady. The case preceded the Zuma decision on which we rely. It is in any event wholly distinguishable. Although motive is irrelevant in the case of public prosecutions, it's obviously not permissible in a private prosecution to use the power to prosecute for personal financial gain. That would totally undermine the objectivity of the prosecuting process. The fourth decision invoked by the defendants is Ruring, N.O. versus Mashlango. You'll find that at page 14, paragraph 29.6 of their heads. That matter, my lady, was concerned with the abuse of the right to cross-examine in an inquiry under section 417 of the then Companies Act.
Sorry, can you just pause? Oh yeah, paragraph 29.6 of the heads, yeah. I found it, that's fine.
That was concerned with the abuse of the right to cross-examine in an inquiry under section 417 of the then Companies Act. That jurisprudence has no relevance to abuse of process as a defense to a substantive claim. The fundamental issue there was whether the inquiry was being used for a purpose not contemplated by the Act. This is again a process which can be abused, as was recognized by the Constitutional Court in the case of Bernstein versus Bester, which is number 38 on our list of authorities. As a fifth case, our learned friends refer at paragraph 29.7 of their heads, page 15, to the judgment of Mojapela DJP in Goldfields v. Motley Rice, which dealt with the validity of Champertus agreements. The remarks made by the learned DJP were concerned with the validity of such agreements, not with the pursuit of legal claims generally. Then finally, there is the case on which they rely is Ascendus Animal Health. There they refer to it at paragraph 29.6. I'd like to take you to the case in their authorities. Their authorities are those that I have are set out alphabetically. So Ascendus is the first case of their bundle. And
Yes, I have it.
paragraph 40. Unfortunately, mine's page 8. I don't know what your ladyship's page is.
Paragraph 40.
Yes.
Although there may be compelling arguments, is that what you're referring to?
Yeah. That is it.
Yeah, sure. I've got it here. Thanks.
Although there may be compelling arguments in this case for the application of the doctrine of abuse of process, I'm of the view that it is not properly before this court. So that what she then says in the rest of the paragraph is obiter. Are you with me, my lady?
I'm with you. Yes.
Let me remind you, that was an unusual case. 10 judges sat. And it was split 5-5. I'm just having a look. Your ladyship wasn't in that court.
No, I don't think so.
And then lower down, the court says abuse of process concerns are motivated by the need to protect the integrity of the adjudicative functions of courts. That's what they quote. Doing so ensures that procedures permitted by the rules of court, procedures, again, we have, my lady, are not used for a purpose extraneous to the truth-seeking objective inherent to the judicial process. Now, my lady, we say that apart from being obiter, as I've mentioned to your ladyship, it is not relevant to the use of abuse doctrine as a defense to a substantive claim. As an aside, my lady, the defendants made no attempt in their heads of argument to deal with the cases relied upon by us for the proposition that the motive behind the initiation of a legally valid claim is generally irrelevant in South African law, at least as a self-standing defense to a substantive claim. To the extent that the defendants contend for a development of the common law through either section 39(2) or section 173, we point out in the first instance that reliance on section 173 of the Constitution was not pleaded by the defendants. As far as section 39(2) of the Constitution is concerned, we do not dispute the importance of freedom of expression in the context of environmental debates. I'm going to deal a little bit with freedom of expression in the United States when compared with South Africa. But late yesterday afternoon, my lady, we got an email from the defendants' representatives to say that they are going to rely on a case called Laugh It Off. Laugh It Off, excuse me, Promotions CC versus SAB International. If you look over my shoulder, you may see a red pillow. You may
Yes,
see
I see that. Yes.
that got from a successful applicant appellant to the appeal court in that matter when we won the case eventually. So
Did Albie Sachs write that judgment?
no, he wrote a long
Poetic judgment.
poetic judgment that already agreed with Moseneke J. And all
Did it. Yeah, but yeah.
it was about, does the law have a sense of humor?
Yes, exactly.
We won on freedom of expression basis.
Yes.
I want to read to you a sentence in paragraph 55.
Yes.
This is what is stated by Moseneke J. Of course, freedom of expression is not boundless, but may not be limited in a manner other than authorized by the Constitution itself, and I emphasize, such as by the law of defamation. That's what we are doing. And this was said with reference to two cases. One is Mama Bolo, to which I shall refer. We did send a copy through to your ladyship. And Kamalo and others versus Holomisa, which is in our heads, in our authorities. It's the judgment of a Regan Day some time ago. We, however, submit that development, bearing in mind what the Constitutional Court says there, why there's room for development of the common law, which would be counter to what I've just read to you, we do not know, but we do submit that development of the along the lines that contended for by the defendants would not strike the correct balance between freedom of expression and the right to a reputation, which flows from the right to dignity. According to paragraphs 47 to 49 of SA Taxi. Let me just stop for the moment at SA Taxi. I was under the very wrong impression that in constitutional circles it's referred to as Media 24, but our opponents call it SA Taxi, so I'm quite happy to you call it the same. That should be in our second bundle. Do you have two bundles from us, my lady?
I have one case law bundle, but I do have SA Taxi because I read it. So we'll just see. I think I flagged it as well. That's Media 24. Let's find it. Right. Let me just see. Yeah, I've got SA Taxi. No, sorry, wait. Just
You may have it as Media 24 on your flag.
Just see. Sorry, I just lost it. Just give me the page.
Page.
Oh yeah, it is, yeah. I found it. I should not be looking too hard for this one. Yeah, I have it here.
Could you go to page 347?
Yes.
Of the court page
Yeah.
numbers, paragraph 47, having at 44 discussed the concept of dignity, referred to Kamalo, referred to the Ruby Day.
Yes.
And you may recall that Brunt, AJ in the Constitutional Court wrote a majority judgment in LaRue versus Day. And yeah, he's writing for the SCA, majority. And he refers to the financial mail case at 45, etc. And at 47, in the light of this historical development, it will be anomalous if the corporation's right to reputation, which through inferential reasoning gave right to the acknowledgement of its right to privacy, would be held not to enjoy the same constitutional protection as its right to privacy. In the present context, I can see no conceptual difference between the corporation's right to privacy on the one hand and its right to reputation on the other. Both privacy and reputation fall outside the ambit of the narrow meaning of human dignity, which a corporation cannot have. At the same time, they both included in the wider meaning of dignity protected by Section 10 of the Constitution. But even if the reputation of a corporation is not protected by the Constitution, it by no means follows that its reputation is not protected by the law of defamation. Though freedom of expression is fundamental to our democratic society, it is not of paramount value, see e.g. Kamala, nor does it enjoy superior status in our law, e.g. SV Mamabola. Accordingly, limitations of the right to freedom of expression have been admitted in the past for purposes not grounded on fundamental rights, e.g. integrity of the courts, SV Mamabola. 49, for the reasons I've given, I believe that the reputation of a corporation is worthy of protection. Moreover, I believe that the common law rule protecting that reputation is in turn recognized by Section 39(3) of the Constitution. In Kamala, the Constitutional Court considered our common law of defamation and concluded that it strikes a proper balance between the protection of the right to freedom of expression on the one hand and the right to reputation on the other. As I see it, this also applies to the reputation of corporations. Milady, you are bound by that judgment, and my learned friends will hope in due course to persuade the Constitutional Court to follow the minority judgment of Nugent J.A. But Nugent J.A., if my memory is right, found that a corporation could have a reputation, but it couldn't get damages if it didn't prove patrimonial loss, etc. And it said you can get an apology, and that we have in any event in the alternative. So we say, if there is to be a development of a new defense, an impermissible motive or purpose alone cannot suffice to constitute an abuse of process. A consideration of the merits must play some role. The reason for this is that the value of speech or reputation, for that matter, depends on whether it is true or not. And we refer you to Kumalo Holomisa at paragraph 35. I'm not going to stop there. The defendants contend for a position where the truth would play no role, and we contend this is unacceptable. Take a pharmaceutical company faced with a situation where activists contend without justification whatsoever that its products are poisonous. Why should such an entity not be permitted to sue the activists for damages and or an apology, even if there's no prospect of recovering damages, and even if the primary, if not the only purpose, is to silence the activists? The obvious harm which may flow from such fake news is that people may refuse treatment which may cure them. The merits must be considered as society's interest in the truth far outweighs the free speech right of the activists. As said, there can be no constitutional interest in spreading falsehoods. As another aside, my lady, could I give you a reference?
Yeah.
McDonald's Corporation v. Steele and Morris. McDonald's Corporation v. Steele and Morris. 1997, EWHC, England and Wales High Court 366. That is a case, my lady. I think the judgment runs to over 1,000 pages, in which McDonald's Corporation sued 2 activists, and they ran this case for a long time. There were other defendants. The other defendants apologized and were left out of the case. And 2 activists went and fought this case day in and day out for more than a year. Our learned friends would say, you must have nothing like that here because you must have slap suits. We know slap suits are all by legislation. You can accept that our parliament is fully aware of slap suits and has decided not to initiate them, as have many states in the United States, as have United Kingdom, all the states other than one territory in Australia, etc., etc. My lady, we contend that it would accordingly be wrong to develop the law in a direction where motive or purpose alone may non-suit a company. Even if the motive were to silence the activists, surely it must be a factor that the company has an overwhelmingly strong case that false information is being spread about its products. That's my analysis case. We accordingly submit that a development which would completely exclude a consideration of the merits of a claim is not one which this court should or can endorse. Our submission is supported by the foreign laws with which we will deal later. These claims, these laws, my lady, require the claims to be meritless in order to defeat them. Secondly, if the aim of the development is to develop a defense along the lines of the slap suit legislation, then the question arises as to the proper procedure which should be used to invoke this defense. An analogous situation was recognized in the case of Jorgensen. Now, Jorgensen is our case number 23. It's called Fisheries Development Corporation v. Jorgensen. It's at my 150, which has a totally different page to your ladyship.
Can you just, is it part of the bundle?
In our bundle, yes. It's our
What's the name of the case?
number 23 in our bundle.
Okay.
It's called Fisheries Development Corporation v. Jorgensen, Fisheries Development Corporation v. AWJ Investments. I must apologize that our pages are not the same. I don't know how that happened.
Did you deliver any bundle on Friday?
No, this is in our original bundle, and our original bundle, I'm totally confused, is identical to what all our legal team had. The one that we delivered is 2 pages to the page.
So on what page are you?
It's called, mine is page 154. Yours could be around about 308, something like that. And it starts Fisheries Development Corporation.
I don't see it in the index, that's why I'm looking now.
It should be. I hope you're looking at our bundle.
Let me just see, what do I have here?
We've got 2 bundles. That's what's worrying me. Volume 1 and Volume 2.
Yeah, it looks like one volume. Let me see. Did you deliver bundles on Friday? Because nothing was delivered to me on Friday.
This was delivered when we delivered the papers with our heads of argument.
Yeah, let me just see.
You don't seem to have our bundle then.
No, I don't have that bundle here. Everything was put in a box and I brought everything home. Give me the citation. I will check. What's the name of the case? It's fine.
You just mentioned, so there's no mistake. My attorney, Mr. Kudo, says he saw our bundle at your chambers.
Mm-hmm.
It's called, can I just give it to you for short? It's
Sure.
called Fisheries Development Corporation v. Jorgensen, 1979, 3SA,
Yes.
1331. At, my lady,
Yes.
1338 F to H.
H to H.
H.
Yeah, thank you.
I'm going to read from the passage. Judgment of Nicholas J., as he then was. It is well established that the court has an inherent right to prevent the abuse of its process in the form of frivolous or vexatious litigation. And when the court finds an attempt made to use for ulterior purposes machinery devised for the better administration of justice, it's the duty of the court to prevent such abuse. And he refers to Hudson versus Hudson, which I referred to earlier as being in Baynes versus Wixley. This power, however, is one which must be exercised with very great caution and only in a clear case. The reason is that courts of law are open to all, and I remind you of Section 34 of the Constitution, and it is only in very exceptional circumstances that the doors will be closed upon anyone who desires to prosecute an action. The procedure adopted by the defendants in raising this matter by way of a special plea is not an appropriate one. The proper course, when a stay is sought against litigation alleged to be vexatious, is to make a substantive application supported by affidavits giving the grounds upon which relief is sought. The affidavits can be answered by the affidavits from the other side, and the facts in that way fully placed on record. To claim this relief by way of a plea in bar is wholly irregular. So we say, apart from Fisheries Development and Jorgensen not supporting them, they also say they've used the wrong procedure. Yes. Sorry, will you just give us a moment? There's 7 people trying to enter. I think they are journalists. So
No problem. No problem.
At some stage, my lady, we would like to get our bundle to you. It worries me because that was there before anybody else. Now we've got somebody who's now live and now has come in.
So who joined us? Is it the journalist?
I don't know.
Anyhow, all is welcome. We can proceed once they have settled.
Huawei phone. That's all I can tell you. That came up.
Yes.
Thanks, I got there.
Anyway, yeah. Oh no, there's. Oh, my lady, can you hear us?
I can hear you. Yes, I can hear you clearly.
Thanks.
I just wanted to state that do not be overly concerned if I don't have the bundles. Just give me the references and I will see to that. I will get hold of it, whether it's with me here or at my chambers. But don't worry if I don't have it. I will note the citations and so on. Thanks.
Thank you. You make a point that's obvious why the dictum which I read to you in Jorgensen must be correct.
Yes.
Abuse of process defense can be raised by way of a special plea, and it will have to be determined after hearing of evidence at trial. You'd have to run evidence on a special plea. The purpose of this so-called slap suit offense, namely preventing a defendant from being harassed by a meritless action, will then not be achieved. This is another reason why the development contended for by the defendants cannot be endorsed. They have not brought the defense sought to be established in terms of the correct procedure, nor contended for the development of a proper procedure to raise the defense they seek to develop. Again, our submission is supported by the foreign laws to which I shall turn later. Now, I want to take you to two cases in our learned friends' heads, which just warrant very quick comment. At page 17 of the defendant's heads, at paragraph 35 and 36, if I could just find that, our learned friends' heads, they quote page 17. Do you have that, my lady?
You have that, yes.
A quote from Sandu versus Minister of Defense, and they say 36, for these reasons, our highest courts have recognized that an order preventing a person from making allegedly defamatory statements is a drastic interference with freedom of speech, etc. Let me remind you that the Sandu case was a case of prior restraint, and prior restraint differs totally from an action for defamation. And there is maybe a bizarre or maybe a startling submission that in the present case, of course, at paragraph 37, they say, the mining companies have not sought interdicts against expression directly. Now, it's a bit difficult. Let me take Riddell, the three ladies. Summer school is over. What interdicts could we ask for what's already been? You can't get an interdict against something that has already been said. The same Mr. Dlamini and Mr. Cullinan have spoken some time ago on a radio program. Mr. Clark has been on print, he's had an e-book, all something of the past. You can't get an interdict against that which has taken place. And they say at 37.2, the mining companies, they seek to achieve the effect of an interdict against the defendants and public at large, but without meeting the requirements for such an interdict. This is impermissible. Lady, this is totally without any foundation. We're entitled to institute action for defamation. We've no Kamalo versus Holomisa. We've seen what Moseneki J said. in laugh it off. We cannot be prevented from protecting our reputation by way of a defamation action. And could I then also take you, they rely at page 19 and page 20, paragraph 56, footnote 56, paragraph 40, as recognized by, last line, as recognized by Baroness Hale in Jamil versus Muhammad v. Wall Street Journal, etc., the power wielded by major multinational corporations is enormous and growing. The freedom to criticize them may be at least as important in a democratic society as the freedom to criticize the government. May I just remind you, my lady, that it's not mentioned that this is a dissenting judgment, not a judgment of the House of Lords, but a dissenting judgment by Baroness Hale. There's no suggestion, as much as I would love it, that my two clients, MRC and MSR, are major multinational corporations. I would love that, but there's no suggestion that they are that. And then she says the freedom to criticize them may be at least, makes no decision at all in that regard. Now we turn next to the Cal's heads of argument. Which contends that a slap suit offence has two elements. Firstly, the case has the intention or ulterior motive or effect of discouraging the vindication or pursuing of rights.
Sorry, can you just pause for a moment? I have the heads in front of me. Where are you reading now?
Cal's heads, page 8.
Oh, page 8. Just hold on a moment.
If I could find it.
Yes, I'm with you.
Give me a moment, my lady, please. This is, they say, it follows from the definition that a slap suit has two elements. First, the case has the intention, or bracket ulterior motive, or effect of discouraging the vindication of rights. Second, the case is a meritless case, and please do not forget that. In America, that has to be asserted, and I will come to that in a moment. How it can be suggested, and what you know, that this is a meritless case, we do not know. But I want to remind you that in the case of LaRue versus Day, LaRue versus Day is the Constitutional Court judgment, which in turn followed the Constitutional Court in Kumalo versus Holomisa. LaRue versus Day, the judgment of Brunt, AJ, as I referred to there, at paragraph 85.
Right.
I could find paragraph 85, yes. He refers to, in paragraph 84, what was stated in Kumalo and others v. Holomisa, and then he says, in 85, yet the plaintiff does not have to establish every one of, now let me go back for the sentence. In Kumalo and others v. Holomisa, this court stated that the elements of defamation are A, the wrongful, B, intentional, C, publication, D, a defamatory statement, e concerning the plaintiff. Yet the plaintiff does not have to establish every one of these elements in order to succeed. All the plaintiff has to prove at the outset is the publication of defamatory matter concerning himself or herself. Once the plaintiff has accomplished this, it is presumed that the statement was both wrongful and intentional. A defendant wishing to avoid liability for defamation must then raise a defense which excludes either wrongfulness or intent. Until recently, there was doubt as to the exact nature of the onus, but it is now settled that the onus on the defendant to rebut one of the presumptions is not only a duty to adduce evidence, but a full one. A bare denial by the defendant will therefore not be enough, and could I then say, read the next sentence. Facts must be pleaded and proved that will be sufficient to establish the defense. You won't find too many of those facts in the special plea. As we've stated, we agree that a slap suit offense can never be recognized without a consideration of the second element, namely the merits of the claim. Now, I have to take you, milady, and unfortunately it seems that you don't have it, to a case called Flatley. Now, I don't know if you, milady, you follow dance, but there is a man called Michael Flatley, who is a renowned Irish dancer. It looks like in this case he was, according to the lady complainant, renowned elsewhere as well. But I want to take you, you'll find this is our case number 41 on our list of authorities. And you may want to make a note that I want to take you to page 12,
Right.
that judgment, and page 14. This is the judgment of 6 judges of the Supreme Court of California on appeal from the Court of Appeal. Section 425.16 therefore establishes a procedure where the trial court evaluates the merits of the lawsuit using a summary judgment-like procedure at an early stage of the litigation, and refers to a section which a case there says is a procedural device for screening out meritless claims. Now, quoting from the Court of Appeal at page 14. First, the court decides whether the defendant has made a threshold prima facie showing that the defendant's acts of which the plaintiff complains were ones taken in furtherance of the defendant's constitutional rights of petition or free speech in connection with a public issue. If the court finds that such a showing has been made, in other words, that the defendant's acts were taken in the constitutional pursuit of its rights to petition or free speech, he then says, the judge, if the court finds that such a showing has been made, then the plaintiff will be required to demonstrate that there is probability that the plaintiff will prevail on the claim. The defendant has the burden on the first issue, the threshold issue. You've got to get over that first. The plaintiff has the burden on the second issue. But a lack of merits has not been pleaded by the defendants in their special plea. And we say that this must have been left out by the defendants by design. The special plea is a self-standing plea. The defendant's position is clear. They want the claims to be dismissed on the basis of improper motive or purpose alone. We further, milady, differ from the position taken by CALS in their heads of argument on the following aspects. Firstly, CALS contends that if the exception is upheld, it will deny the defendants their rights in terms of Section 34 of the Constitution. It's a bit startling, but this submission, we contend, is unsustainable. The whole purpose of the exception procedure is to prevent a waste of time and resources on claims that have no basis in law. If CALS is correct, then the entire exception procedure should be abolished, and our Section 34 rights under the Constitution fall to the ground. CALS also relies on a case called Christensen N.O. v. Richter. I didn't find it in the bundle, but I may be wrong. But I do refer you to paragraph 16 to 19 of the judgment in Christensen by Judge Tefo, sorry. And we commend to your ladyship the summary of the law as set out in that matter from paragraph 16 to 19. CALS is not, plaintiffs are not seeking costs against CALS, and we know that such an order is seldom if ever made against an amicus curiae. We now, at my lady, turn to deal with some of the foreign statutory slap suit defenses. The one that I referred you to, my lady, was Flatley. That is a slap suit defense in California, one of the states that does have anti-slap legislation. First, the substance of the legislation is relatively complex and quite obviously underpinned by policy considerations peculiar to the foreign jurisdiction. Could I remind you, my lady, that in defamation cases and most litigation in the United States, the successful plaintiff doesn't get a cost order. So the case runs, and you may get a big award, but if you run litigation in the United States, you are not under threat to pay a cost order. And we do also know that defamation cases in many states are run before juries. Thankfully, we don't have that. Yeah. The legislation, milady, where the provision is made for anti-slap suits, establishes special mechanisms which entail a summary special motion procedure on affidavit to be brought by the slap suit defendant at an early stage of the impugned litigation. This is consistent with an important aspect of the purpose of anti-slap legislation, the saving of time and money for the benefit of the targeted defendant, and I assume also for the court. Thirdly, the successful failure of a special motion is dependent on the merits of the impugned litigation. In order to illustrate this, my lady, it's convenient to have regard to the foreign legislation the defendants rely on in their heads of argument. It concerns certain, but far from all the states in the United States of America, certain provinces in Canada. In the United States, the defendants rely on the California Code and the Georgia's Code. In Canada, on Ontario and Quebec's legislation. Particular caution, my lady, needs to be applied to the American legislation. I want to take you to the case which we sent through some time ago to your ladyship, called S. v. Mamabola. It is 2001 3 SA 409 Constitutional Court. This was a judgment of Krichler J, and I have a feeling, because I don't have the whole, I don't have the whole case here. Can you just get it quickly? 2001 3. I have a feeling that that was written for by far the majority, but we'll get that. I don't have the whole one with me. 2001 3. At paragraph 21, Krichler J says, let's have a look at it. One notable exception to the list of common law jurisdictions recognizing this particular offense in the United States, let me stop, that's called scandalizing the court, is the United States of America, which has, as is well known, its own historically rooted special reverence, I emphasize, special reverence for the First Amendment and the preeminence it affords freedom of speech of the media. We're not really talking about the media here.
Everyone concurred in Sachs wrote his own concurring judgment.
So it's similar to laugh it off. Everybody concurred with Krichler J, and then Sachs, who did concur, wrote a concurring judgment. Those were the days when he was poetic. Now we go to 35. Mr. Marcus took a less radical line in pressing the argument on behalf of the amici, namely that the test for scandalizing should be adapted to accommodate a heightened claim of the right of freedom of expression vis-a-vis the reputation of the judiciary in the constitutional era. He was content to support the decision of the majority in the Ontario Court of Appeal in the Capito case. That was to adapt the clear and present danger test applied by the American courts when dealing with challenges to the First Amendment and the protection it gives to freedom of expression. I respectfully share the misgivings expressed by Gabe C.J., former Chief Justice of Zimbabwe, and Bedouben J.A., who was in the minority in Capito, a Canadian judge, about the suitability of that test in a jurisdiction that does not have to apply the First Amendment, nor enjoys the benefit of the extensive and complex jurisprudence so carefully constructed by the United States courts. And Mr. Justice Krichler in paragraph 36 says he is unpersuaded by Gilbert Marcus's erudition and eloquence. And it says the following at paragraph 41. A detailed analysis of the difference between the two constitutional regimes is unnecessary. Here we are concerned with one crucial difference. The fundamental reason why the test evolved under the First Amendment cannot lock onto our crime of scandalizing the court is because our Constitution ranks the right to freedom of expression differently. With us, it is not a preeminent freedom ranking above all others. It is not even an unqualified right. I read that to you already from SA Taxi. The First Amendment declaims an unequivocal and sweeping commandment. Section 16(1), the corresponding provision in our Constitution, is wholly different in style and significantly different in content. It is carefully worded, enumerating specific instances of the freedom, and is immediately followed by a number of material limitations in the succeeding subsection. Moreover, the Constitution in its opening statement and repeatedly thereafter proclaims three conjoined reciprocal and covalent values to be foundational to the Republic: human dignity, equality, and freedom. with us, the right to freedom of expression cannot be said automatically to trump the right to human dignity. The right to dignity is at least as worthy of protection as the right to freedom of expression. How these two rights are to be balanced in principle and in particular, any particular set of circumstances is not a question that can or should be addressed here. What is clear, though, and must be stated, is that freedom of expression does not enjoy superior status in our law. And that runs counter to our learned friends' arguments. I just want, while talking about that, I want to go back for a moment to that judgment of the Concord in Laugh It Off, which was raised yesterday. And I want to read you a sentence from paragraph 47. Plainly the right, says Moseneki J, plainly the right to freedom of expression in our Constitution is neither paramount over other guaranteed rights nor limitless. As Krichler J. in Mabola puts it, with us it is not a preeminent freedom ranking above all others. It is not even an unqualified right. And then I just want to, I have referred you to SA Taxi, I think it's paragraph 48. And I want to refer you to the judgment of Nugent J. A. in a case called MIDI Television. It is number 8 on my learned friends list of authorities. And I just want to give you reference to paragraph 14, where he says the same thing, with a reference to Mama Bola and maybe Kamala. So we know, as Krichler J. said, that our Constitution does not have the special reverence for free speech, which is to be found in the First Amendment of the United States. I want to refer you, if I may, and we did give you a copy of the first 21 pages of a book by Sheldrick, S-H-E-L-D-R-I-C-K, called Blocking Public Participation, the Use of Strategic Litigation to Silence Political Expression. At paragraph, page 12, the learned author says, the specificities of the American constitutional system and the First Amendment right to petition government have played an important role in defining slaps. Now, we do not have that in South Africa. And we then take you on a quick analysis. I'm not taking you through countless cases. First, we tell you that slap suits in California are regulated by section 425.16. You'll find that in Flatley's case, my lady. Apparent from the code itself that that's intended to protect the American constitutional right to free speech in the context of participation in matters of public significance. I do assume, my lady, that old tunnies going to the summer school in January on holiday from Johannesburg and Cape Town may fall within this public significance because they're sitting and listening at a university. That will obviously in due course come up at the trial. A defendant confronted with a lawsuit that threatens its participation in a matter of public significance in further of its free speech rights may bring a special motion to strike the lawsuit in California. The motion must be brought at an early stage of the impugned lawsuit within 60 days of service of the lawsuit or at any later time that the court may deem proper. It shall be set down for a hearing no more than 30 days thereafter. Launching a special motion to strike stays the impugned lawsuit prior to the discovery stage, thereby applying a break to legal costs. The motion is dealt with as set out in the Flatley case, and I don't need to say that the determination is made with reference to pleadings and to affidavits filed. The potential for the abuse of the special motion proceeding, my lady, is mitigated by costs awards. So usually in America, and if you take a slap suit, a defense, and you are thrown out, you could well have a cost awards against you. Do I really need to take you through to Georgia? My lady, we've, in Georgia, there's a requirement for a motion to strike as well, and in recognition of the potential for abuse, an applicant who is found to have acted frivolously or with an intention to cause delay shall be ordered to pay costs. In Quebec, the motion is called a preliminary exception, but dismissing the case is not amongst the options. In Ontario, in Ontario, the Protection of Public Information Act seeks to encourage individuals to express themselves on matters of public interest and discourage the use of litigation as a means of unduly limiting expression of matters of public interest. The Act makes provision for a motion for the court to dismiss proceedings arising from an expression made by the person that relates to a matter of public interest, which shall succeed unless the responding party satisfies the court that, one, the impugned proceedings have substantial merit and that the defendant, in essence, has no valid defense. Now, in conclusion to my part of the argument, I want to take you to my learned friend's heads at page 27, paragraph 28. Paragraph, let me just find it. Just on the floor here. Sorry. Page 27, paragraph onto 28. There's a reference to the Delhi High Court. You remember that?
Yes.
Okay. Now, it's quite interesting to know what they do in Delhi, but when you go to Delhi, you must actually read the previous paragraphs as well, which is not being done here. So I want to take you to this case called Crop Care Federation of India. You'll find that in the defendants bundle, my lady, and it's on the second page of the list referring to the Crop Care Federation case. If you could find it, I would be very happy.
Yes, I have it in the bundle here.
This is Crop Care Federation of India. Could I take you, my lady, to paragraph 20? Paragraph 20, and it starts, that I can't see the page.
Yes. Yeah, I've got paragraph 20.
Order 7, Rule 11
Yes.
requires the cause of action to be disclosed. Can I take you to the last paragraph of that paragraph 20? In light of the above discussions, the plaintiff, read as a whole, cannot be said to have disclosed the cause of action disclosing any defamation. The plaintiff is therefore liable to be rejected under Order 7, Rule 11 CPC, and the suit is non-maintainable. So you see there, in essence, an exception has been upheld. The case is thrown out, but the judge decided to go to paragraph 23, which is quoted in extenso in my learned friend's heads, and this is clearly, oh, it's in 53 of his heads, this is clearly obiter in a situation where the court has held there's no cause of action and where the plaintiff was suing in a representative capacity. So some Indian judge, maybe one of their best judges, has read Judge Nicholas Columbella from the New York Supreme Court, and he then quotes it. But the matter is not decided by SLAP. There's no suggestion that SLAP is of any relevance in the United States, I mean, in the state in which Delhi is. And my lady, is there anything that I need to do? My learned friend, Mr. Duval, will take over from me.
It's 11:30.
It's now 11:30. Can we break until 10 to 12?
That's right. My clock is also at 11:30. We shall then adjourn and come back at what time?
11:50.
That's fine. 11:50. 10 to 12. Thank you.
Thanks.
Okay, fine. Okay. No, Peter, I thought that went well.
Are we ready to start? Can you
Yes,
hear
my
me?
lady, I believe
You
so.
ready?
Yes.
Okay. So it's your turn now.
Yes, thank you, my lady.
Thank you very much.
I shall only refer to the UCT heads of argument. So if I can ask you to locate those.
Yes, I have it here.
I'm not going to refer to anything else.
That is fine. Thank you for letting me know in advance. Right.
My lady, I'm dealing with two aspects, as Mr. Hodes said at the beginning. The first is this aspect of academic freedom.
Yes.
And the second is the issue of costs. Before I start, may I just put the academic freedom argument into some kind of context? Because as Mr. Hodes said at the outset, there are two special pleas, and my clients have accepted to both of those special pleas. Now, our exception to the second special plea, that one dealing with a trading corporation, that is conceded by the defendants. We're not too sure what Cal's position is, but the defendants concede that you have to uphold that exception because of SA taxi. Because that was the argument which was made there, and the decision was 4-1. And therefore, they cannot plead as they do. What they want to ultimately, I suppose, do is to establish this trading corporation defense in the constitutional court. But that's for another day. And the academic freedom argument, of course, got nothing to do with that. Then there's the first special plea, which is the sort of abusive process and slap defense. That special plea is taken in all three of the cases. But the defendants say with, and our exception is, of course, that there is no such defense in our law. There is no slap defense in our law. What the defendants are saying, you would have seen, is that you can fit that into our law under the abuse of process doctrine. And we say no. Mapanga, the decision of the SCA, defines and circumscribes the abuse of process doctrine to the extent that you are going to use it as a defense to a substantive claim. There may be categories outside of that when it comes to abuse of the court's procedures. But Mapanga describes fully what our law is in respect of an abusive process. And it says that the claim must, as a matter of certainty, lack merit. That's the definition of it. So as the law stands, we say they're dead on the first special plea because of Mapanga. They have to argue for a development of the law. And that development they have argued for under section 39(2). And I see in their heads also with reference to section 173, although that wasn't pleaded, but be that as it may. Why do we say, as Mr. Hodes explained, why do we say that the law cannot be developed to allow for this new slap defense? We say that for two reasons. And the first reason is simply that everywhere in the world, the merits, my lady, is also taken into account in these slap defenses. And there's a good reason for that. Because if you look at motive alone and not merits, then as Mr. Hodes used the example of a company with a good product, but now an activist is saying that product is poisonous, and as a result of that, a whole lot of people are not using it. one must say at some point, even if that company is using the defamation suit to silence those activists that lie about that must be allowed. And that motive alone cannot constitute a defense in terms of SLAPP suit. That's the first reason why we say you shouldn't establish or develop the law, because they want the law to be developed to look at motive only, my lady. They want you to disregard merits completely in their version of the SLAPP suit defense, which is not done anywhere in the world, as we understand. But there's a second and important reason, which Mr. Hodes described to you as well at length, and that is that in order to develop a SLAPP defense, you've got to create a procedure for how that defense is raised. You can't just say as a matter of substantive law, we're going to introduce a SLAPP defense into South African law. Overseas, they've got a whole special procedure. It almost works like a summary judgment, where the defendant can bring a motion to have a claim, a defamation claim, struck out on the basis that it's a SLAPP claim. And one then has to ask yourself, how is this going to work? It must then work in a way, by way of motion proceedings, and we will be the respondents in that matter and so on. They haven't pleaded how the procedure will work. Somehow they want this to be dealt with at the trial. Well, that will be a massive waste of time, because then we have to go through a whole trial dealing only with the SLAPP defense and the question of motive, and thereafter deal with the merits as well. The whole idea about a SLAPP defense is it gives you a sort of summary judgment defense, a summary judgment procedure for the defendant to knock a claim out. So they must explain, and they should have pleaded how that will be developed. My lady, that was a bit of a longer introduction, I'm sorry, than I anticipated. But where does the academic freedom argument come into all of this? Well, the short answer to it, it doesn't. It doesn't relate to any of this. What happened was that UCT joined the Riddell matter, the one matter, at a time before these special pleas were raised. So they then, as you would have seen from the application to be admitted as an amicus, they then said that they want the law to be developed in a different direction. They want academics to have qualified privilege. As your ladyship knows, the qualified privilege exists in civil proceedings. So if you say something in civil proceedings, you can't be sued for defamation unless it's made with actual malice and it's irrelevant to the matter. They want something like that, that an academic can't be sued for defamation unless there's actual malice or unless it's irrelevant. They want that to be developed. And then secondly, they say, we must develop for the academics also the Bogoshi defense that your ladyship knows is a defense for the media. The publication is reasonably made in the circumstances. Even if untrue, it's protected, it's reasonably made, and that often translates into the question of whether the journalist at least phoned the person who was going to be defamed and asked for their views. So these are the two things that UCT wanted to add to this party before the special pleas were raised. But they somehow stayed on board even after the special pleas came in. And they decided to participate in this round. But your ladyship, if I can take you now to paragraph 17 and 18 of our heads. Because there you will see that they are not too sure what they're doing as part of this case. Mr. Katz is a rebel without a cause in a way. Maybe not the first or the first time. But if you look there at paragraph 17,
I was with your heads now.
No, lady, I will only refer to the Yes.
Can Mr. Katz hear you?
Yeah, but he can't speak, my lady. This is the huge advantage of this. I can, however, he's now switched his mic on.
I'm
lady,
sure
I have
you
no
need a
problem.
lot.
Mr. Duval is a good friend of mine. Friends can say what they want, they'll remain friends. Thank you, ma'am.
We will take it in that spirit. He's giving me a good laugh today.
Thank you, my lady. Thank you.
So,
Where are we now? We're busy with your heads.
no, my lady, it's the UCT heads.
Oh, UCT, yes, I have it here. You referred me to paragraph?
If you go to, if your ladyship can go to page 6, paragraph 17 and 18.
Right.
This is where at paragraph 17, your ladyship will see that they summarize there what I was saying.
Yes.
Is that they contend that the law should recognize a qualified privilege for academic speech. And then they go on to say that academic speech should be defensible on the grounds of reasonable publication. That's the Bogoshi defense. That's what they wanted to do in this matter. But then they go on to paragraph 18 to admit now UCT stands by those arguments. However, the issues currently before this court are more circumscribed. That means that their defenses, their qualified privilege and reasonable publication, that is now not before your ladyship. We don't know how they are going to introduce this, because the defendant must obviously raise those defenses and argue for that development. I can't see how an amicus can raise a new defense on behalf of a defendant in an action. But anyway, I just wanted to make very clear that that qualified privilege and reasonable publication argument is not before your ladyship. They somehow try to fit in and support the defendants in some ways. And of course, that can only relate to the Riddell matter, and it could only relate perhaps to the development of the slap suit defense. But we're not exactly sure how it is. But we'll no doubt hear from Mr. Katz later on how exactly it works. That's by way of introduction, my lady. If I can then take you just 2 pages further to page 8 of these heads of argument. And with great respect to them, we believe that this description of academic freedom that they set out here is actually quite good. And that we don't have serious difficulties with the way that it's described here. Your ladyship will see there in paragraph 26, they say that the first aspect of the academic freedom is that of the institution, the university. They call it the institutional component, which is the right of the university to regulate their own affairs. This is the autonomy of the university. And they quote there, your ladyship will see in paragraph 26, from a judgment of Frankfurter J in the US Supreme Court in the case of Sweezy. I hope I've got that right. Sweezy versus New Hampshire. That's a 1957 decision. And what is emphasized here is that the first aspect relates to the university's right, your ladyship will see halfway through that quote, to determine for itself, and over the page on page 9 at the top, to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. So that is the institutional component identified there by Frankfurter J in Sweezy. I must just say that was a concurring judgment in Sweezy's matter, but we understand that that statement made there was later approved by the full US Supreme Court in other cases and has now become a description. And what is quite interesting, although not very relevant, is that it was South Africans that defined it in that way first. But here, your ladyship will see at paragraph 27, my learned friends seem to think that it comes from a statement from South African academics from WITS and UCT in 1974. Well, that can't be right, because that judgment was written in 1957 already. So it was, in fact, as your ladyship, if you look at the judgment, the Frankfurter J, that's in the bundle of authorities of UCT, it was 2 retired South African judges who made that statement there and gave that description of the institutional autonomy of the university. It was the former Chief Justice St. Livers and Judge Featon who wrote an article in the 1950s dealing with open universities. And this statement is then picked up by the US Supreme Court in Sweezy's case by Frankfurter J. But we agree with this description of what the institutional component means. We just make the submission that component is not engaged in the Riddell matter. Nobody's saying in Riddell that the university's autonomy is being impacted on or interfered with in some other way. It is not a case about the university's autonomy. Then the second aspect dealt with UCT is, for example, not sued. It's not even a party. But if I can go to the second aspect in paragraph 28, this is the individual right of academics. Have your ladyship got that, paragraph 28?
Yes.
Here they deal with the second aspect. And again, we agree that the second aspect is the individual academic's right to teach and to do research. It is particularly the research, my lady, which is important, the research and the publication in the journal. That is the heart of the individual academic's right. And so we ask ourselves, is that component now engaged in this matter? What is that component, and has it been somehow infringed, or will it be impacted on, or will it be chilled if our defamation case were to proceed and eventually be successful? We say that it is not, again, our lawsuit has got nothing whatsoever to do with academic freedom in the individual right of academic sense. Your ladyship will see at paragraph 32 what they define this individual academic's right to be about in their heads. They say their academic freedom is intricately connected to the special role of academics. Traditionally, universities have been regarded as a distinctive task, and now the one that I want to emphasize. It is the methodical discovery and teaching of truths about serious and important things. So it is scholarly inquiry. It is scholarly activities, research and publication in academic journals, what that individual right is about. This is not what is at stake in the present case, my lady. Firstly, and I say this for 2 reasons, and I'll be brief on these 2 reasons because it will be obvious to your ladyship that we're not dealing with academic freedom when we're talking about what happened at that summer school with Riddell and others. Firstly, they are not academics. They are not academics. The one is an attorney and the other 2 are called activists. The academic freedom only belongs to academic staff of universities. And in fact, it is quite interesting, if we can start with a lawyer, the attorney, that in the article that is referenced at footnote 7 of their heads, the article by Robert Post, I'm not going to take your ladyship there, but it's page 80 of the bundle. Your ladyship will see Professor Post, I think. He describes there what is the difference between what lawyers do and academics do. He says there, an academic strives for the discovery of new truths, the advancement of new knowledge. Us lawyers, we don't do that. We apply existing expert knowledge. So it's per definition a different job. The academics are methodical, they discover and they seek new truths, whereas Professor Post gives us a more mundane role of just applying existing knowledge. So it cannot be contended that the attorney that spoke at the summer school has the academic freedom. And it's quite important because your ladyship will see why the actual author is important at the next page, at page 11. And again, they describe in this quote, or the quotation describes very well why must we make a distinction between academics and lawyers and activists, for example. And your ladyship will see there the reason is set out. The academics are screened. They've got to have certain qualifications. When you apply, I think the Americans call it tenure. I think us, we call it just a permanent appointment. But if you want tenure, then it's a tough process to qualify for that. So it's not everyone that has this freedom, because they sift them, they screen them out, and only those who survive that quality control, ladyship will see they use the term quality control there. Those are the ones that get this freedom and the extra protection from section 16. Not everyone, but those that pass that quality control, the best students that get appointed to become the professors. Those professors in turn cannot just publish. They can publish only in journals after their articles are peer reviewed by people. So it's not something that someone from the street, an activist or a lawyer, can usurp for themselves. You've got to go through that rigor of passing the quality, passing the screening, and so on. So we say for the first reason why the academic freedom is not relevant is that they are not academics. The second reason is that we were not dealing with an academic topic here. We are not dealing with scholarly activity. And your ladyship would, again, they very helpfully referred to a case of Unterwager versus Salter. That's a case that your ladyship will find in your bundle at page 67. And that case ends up with explaining why there's a distinction between scholarly activity and other speech, and why the scholarly activity shouldn't be the subject of defamation suits. And at page 67, your ladyship will see the court there says that scientific inquiries must be settled by the methods of science. Scientific inquiries must be settled by the methods of science and not the methods of litigation. And we know why that is so, because when we're debating science, when we're talking about scholarly activity, the court is not in a good position to judge who's right or who's wrong. These are scientists now debating. That's why they've got to fight it out in their journals, their scientific journals. But in this present case, we are not dealing with science. What are we dealing with, my lady? We're dealing with allegations made that my clients don't comply with legislation. They say that we do not comply with legislation such as planning laws and mining laws. And they further say they make allegations of bribery against us. Now, this has got nothing to do with scientific inquiry, with scholarly activity. And therefore, it's the court is not in a bad position or in a weak position to assess these claims and determine these claims, because it's what your ladyship does every day, is to determine whether someone comply with the law. Well, your ladyship is judges are people who are experienced in determining claims of bribery. This is what the courts are all about. And it's not the kind of environment where we deal with complicated scientific claims and disputes between scientists, which is what the individual academic freedom is about. The mere fact that these three individuals, Riddell, Davies, and Cluter, spoke at the summer school, that, my lady, we would submit is far too tenuous. I don't want to knock anything at all and don't want to sound disrespectful, but the summer school is essentially a sort of talk shop. The people, there's no admission requirement, there's no exams, it's lectures for the public. It's not part of the core academic activity at all. Certainly, as far as these individuals are concerned and what they said, as I said, it was straightforward allegations of non-compliance with laws and allegations of bribery. So you can never in 100 years fit that in under academic freedom. And if your ladyship want to contrast it, for example, with what we see, the cases that they refer to, some of those cases, very interesting cases. Unterwager versus Salter, I've already referred your ladyship. That case concerned Unterwager. This individual published a book in which he essentially said that children are terribly unreliable when they give evidence in sexual molestation cases. And he had a whole scientific or pseudo-scientific reason why. And of course, my lady, the reason why Unterwager did this is because he was then chosen by defendant lawyers in sexual molestation cases, and he appeared in over 200 of them, each time arguing. I'm sure your ladyship in the RAF cases have encountered some of these individuals as well. But he was the favorite amongst the defendants, the accused lawyers. He comes up with his theory there every time when a child speaks there. And then Salter took him on. And Salter took his signs on. And then he sued her for defamation. And there the court said, no, I'm not going to engage in this. Is a scientific debate between you two. And I'm not going to allow Unterwager's claim against Salter, who's basically trying to silence Salter, who's questioning his science. So this case is nothing like that. It is a straightforward claim. Are we complying or not with the legislation? And your ladyship, the other one that I found quite interesting as well is the case of Singh versus the British Chiropractors Association. I don't know whether your ladyship are a fan of them, but they historically have made all sorts of claims, the chiropractors. They believe that the spine connects the brain with the body, and therefore if you work on the spine, you can cure all sorts of diseases. And here it concerns their claim that they can solve children's ear infections and so on. So Dr. Singh was saying this is nonsense. You cannot cure anything except perhaps someone's back problem. And then they sued him. And again, your ladyship can obviously see in that situation that this is a debate on science. It is about whether chiropractic has got any validity or not, and more particularly with a more expanded claim that it could cure other forms of diseases as well. My lady, against that background, I will now just quickly end up on this leg by referring you to their 3 points that they make in the end. Why are they relevant? The UCT Council have got 3 points where they say their heads and their arguments are relevant in 3 ways. And that's summarized at page 18, paragraph 57. Your ladyship got that?
You say 57?
Page 18, paragraph 57 on page 18. This is the UCT heads, my lady. Maybe if they...
Yes, are you
so
talking about the heading that says defamation and academic freedom? Are you on that heading now?
No, my lady, I'm further down in the UCT heads. The heading is academic freedom in this case. So it's on my page 18. Yes, it's about 3 pages on. Sorry, 3 pages on.
Oh yeah, I have it. Yeah, it's on page 18. Yeah. Now it's because you were talking about 3 points, but the first 3 points are on page 14. Yeah. Now first, second, third. Also 3 points there. No, that's fine. I'm with you. Thanks.
The Germans have got a theory that their heads are. It's all theory in search of application. But anyway, here they now try to apply whatever they say about the institutional and the individual academic freedom to our matter, the Riddell matter. And at 57, they say first, the speech at issue in the Riddell matter is undoubtedly academic speech. Now, it's undoubtedly not academic speech. It was not made by an academic, and it wasn't about any scholarly activity. It wasn't about any research. It was an allegation of non-compliance with law. So we say that can never be. Then at 59, if your ladyship got that, it's just lower down on that page. They say, second, the suit itself will have a chilling effect on all similar academic activities. Now again, my lady, it cannot have a chilling effect on academic activities because none of the defendants in the Riddell matter was engaged in any academic activity. It's not Salter who's trying to show up Unterwager and these theories about children in sexual molestation cases. It's not that kind of matter. And in any event, my lady, academic activity involves the search for new truth, or at least the search for truth. And it's ironic in a way, because if this slap suit defense of theirs is upheld, then we will never know, of course, whether the allegation of non-compliance with laws is true or not. Because what the defendants want to do is to avoid having to deal with the question of what's true or not true. If the slap defense is upheld, it is all about whatever my client's motive was, the ulterior motive. Let's not go as to what we said was true. Let's just look at your motive. Your motive is to silence us. And on that basis alone, you must be non-suited. And we're not going to get to the truth. And the third aspect, my lady, and this is the last one, you will find over the page at page...
Sorry, can you just pause? I'm looking at 59 and I see the word activists there. Where do the activists fit in? Those who are invited by universities, and you have someone talking about global warming or mining companies who say an activist comes to the university and there's a speaker there and says, oh, the mining companies, they are destroying nature, they're not rehabilitating after they have mined, or they are thieves, or they disadvantage smaller communities, etc., etc. Vis-a-vis the academic, I understand what you're saying there. But what about activists? Are you saying activists are not academics and they can be, they do not require any level of
extra protection?
Yes. Yeah.
No, my lady, we're not saying that at all. And I picked up the word activist at paragraph 1 of the heads, where UCT says this matter concerns academic speech by 2 grassroots activists and a local attorney at the University of Cape Town Summer School in January 27. We have no difficulty with protection for activists, but they are engaging essentially in political speech and not academic speech. That's the only point we make. So to the extent that they are entitled to more protection, or because they are making a political statement and the political discourse mustn't be suppressed, that's a different argument. For the moment, we are talking purely about academic speech, and we submit that activism is by its nature not an academic inquiry. It's not an academic research type of activity. That's the only argument.
But look at HIV activists. They possess a lot of scientific knowledge in that area. And I'm just trying to engage you on how should the court treat the activists who may also have academic knowledge on an issue. Because we cannot say activists are not academics. Surely we cannot just say that and as a fact.
My lady, I'm going to I'm afraid I'm going to have to repeat. The activists can clearly be.
Understand that. Yes.
The activists can clearly come in under academic freedom if they meet the 2 qualifications. One, they must be a member of staff of the university, and 2, they must engage in scholarly activity. So academic freedom, as I argued earlier, is reserved for academics who engage in scholarly activity. That's the argument, and that's what the cases show. When an activist engaged in scientific requirement, then perhaps they can, in that way, when they're talking about HIV/AIDS and that there's a need to distribute medicine and all of those things, they of course protected under the freedom of expression clause. But I think it would be wrong to then try and say, well, look, this is an academic freedom issue. That's the only point. It's certainly protected speech, but we're not accepting that it's academic speech. Malady, can I just make the last point, which I can be brief on, and it's now right at the back again at paragraph 63.
Right, I'm with you.
There, they make their 3rd point, where they say, third, from the perspective of academic speech, it is justifiable to treat trading corporations differently. Now, it seems to me that that is anyway relating to an aspect which is not really before you, but as the Constitutional Court has unambiguously held, juristic persons are not the bearers of human dignity. Section 10 of the Constitution is headed human dignity. Corporations have no right under that section. Even if corporations have common law rights to reputation, that right does not attract constitutional protection. Now, Mr. Houdis has read to your ladyship earlier SA Taxi at paragraph 47, and I'm not going to go back there now, my lady, because SA Taxi refers to this quote. This comes from the Hyundai case. Your ladyship will see there footnote 35, that is Hyundai. And SA Taxi at paragraph 47 deals in terms with the statement of the Constitutional Court. It refers to it and it says, what the court means is that the common law right to dignity is narrow and has only got the dignitas components, but the constitutional right to dignity includes the right to reputation. Now, they can argue that that's wrong, but that's what the SCA said in SA Taxi. It says, pertinently, that corporations have a constitutional right to dignity in the sense of a right to a reputation. Lady, that's just that qualification, and then I'm finished, and I've got to say something in 2 minutes about costs.
Can you pause for a moment? So
Yes.
is that the problem we have here? Is balancing the right to freedom of expression vis-a-vis the protection of reputation and a good name? Is that the problem here? How do you balance that?
There is a balance that must be struck. We're not so sure that the issue of whether someone is now a corporation or not is so central to your ladyship, because that's the second special plea. The first special plea is the slap suit defense, which also requires that balance between freedom of expression on the one side and the reputation on the other. And that those two must be balanced. And what essentially the defendants are saying is that our law is wrong because it's got to introduce a special extra defense for defendants, which defense more or less is that you've got an ulterior motive in suing me. You are not really after recovering any money because we don't have any money. And therefore, because you have an ulterior motive, on that basis alone, a claim can be dismissed. And we say that doesn't strike the balance in the right place. Because if your ladyship look at the overseas cases, they always take into account the merits in these slap suits. They always, to some extent at least, take into account the merits, and they throw that into the pot. And then there's certain other procedures that have developed around the slap suit defense. So we would say that you can't, anyway, it's not relevant to the present matter, but the right to reputation is certainly something which is protected by the Constitution in terms of SA taxing. It's protected by the Constitution, not only the common law. And again, if they want to argue that's wrong, then they can, of course, go to the Constitutional Court as they already are doing. Lady, is there any other aspect?
No, I think I am satisfied with your part of the argument.
My lady, I just need to deal with it.
It just struck me the question with regard to activists. Are you saying that activists cannot participate in academic discourse? Is that what you're saying or not?
My lady, if someone is not an academic, but they genuinely add to science, then I would accept in those circumstances. If it's a scholarly activity and a research that contributes, then for present purposes, I'm happy to accept that such an activist can find protection or additional protection under Section 16. But we are not talking about that kind of thing in this case. We are talking about people, a lawyer who are saying that we don't comply with the law. I don't see how that can be described as any. This has got not. So I'll leave it at that, if I may.
Yes.
My lady, can I just say 2 or 3 things about costs?
Yes.
I think Mr. Hout has already mentioned to you that nobody is seeking costs against the amici.
Yes.
You can't give a cost order. Sorry, we're not asking for a cost order against the amici, and they can't get cost against us. So that seems to be common cause.
Yes.
As far as the defendants are concerned, we make the submission that BioWatch does not apply. It doesn't apply in litigation between private parties. Our learned friends, I think, accept that, but they refer to the Constitutional Court's judgment in Barkhuizen versus Napier, where the Constitutional Court, your ladyship will remember, that's a famous case dealing with the limitation clause in a contractual term that limited the right to institute proceedings, I think, for a certain period of time. And the Constitutional Court in Barkhuizen said that, no, we're not going to give any cost order because they brought an important constitutional challenge in contract law and it assisted everyone. But my lady, Barkhuizen wasn't so much a case about balancing fundamental rights. It was not so much a case about that, and it wasn't this case about the balance between dignity and the form of reputation and free speech. So we would just like to refer your ladyship to the Constitutional Court judgment in Khumalo versus Olamisa. Your ladyship would have that case somewhere, but I'm not going to try, and your ladyship will just see at it's a unanimous judgment authored by Reagan J. And it is, of course, a case dealing specifically with an exception in a defamation case. So we would submit it's on all fours to our matter. And in paragraph 46, she deals with, Reagan J. deals with the costs like as follows. She says, this case did not involve a state or an organ of state. It was a dispute between private parties. The applicants have failed in the appeal. In the circumstances, it is fair that the respondent should be awarded costs. So she's very clear there, paragraph 46. In the defamation case, in the exception case, she says that no, there the cost must follow the result, and that's what we say should happen here as well. My lady, those are our submissions on the academic freedom and costs, and if there's nothing else, what do I say? Do I say I mute myself then at that point?
Thank you very much for your submissions. Thank you.
Milady,
Yes.
Milady, my learned friend, Mr. Budlander, will be making the oral submissions on behalf of the defendants in this regard.
Shall we proceed now?
As the court pleases.
Thank you very much.
Good afternoon, my lady.
Good afternoon. Are you father and son?
We are, my lady. We've tried to, we found it produces less family disagreements if you're on the same side than if you're on opposite sides, which doesn't do well for dinner time conversation. So we've been trying to avoid that.
I wanted to say I'm glad to see you on the same side, yes?
Yes, absolutely, absolutely.
Thank you very much, Advocate Budlander. You may proceed.
Thank you so much, my lady.
Can you just give me an indication? Is there anything I need to put in front of me first?
Please, if you could get our heads of argument, because I'm going to follow the scheme in our heads, and it will assist if you have that in front of you.
Right, I have your heads right here. Sorry.
Thank you so much.
Yes. Thank you very much.
Thank you, my lady. My lady, you've heard a lot of argument today. You've heard references to cases all over the world. You've been taken to more cases, I think, than is normal in the course of a morning. But it's necessary to just step back and remember what this case is actually fundamentally about. This case, or these three cases, are about three actions launched by a group of mining companies and their directors, in which they seek, in total, 14.25 million rand in damages. And who do they seek that from? They seek that from 3 environmental attorneys and 3 community activists. The balance is different in the different cases. The one's 2 attorneys and 1 activist, but overall, we have mining companies and their directors suing 3 environmental attorneys and 3 community activists for damages in a total amount of 14.25 million. And in circumstances, my lady, where they don't plead that they have been financially harmed by what has occurred. So there is no allegation that, for example, Mineral Sands Resources has somehow suffered losses as a consequence of the statements that Ms. Riddell or Ms. Kitty made at the UCT summer school. Now, you'll know, my lady, that that is partly the subject of the second special plea and exception, and we accept that you're bound by SA Taxi. Is that even permissible in our law? But I'm making a more profound and contextual point, if I may. I'm making the point that what this case is really about is what the law says, what protections the law offers to activists and lawyers and the public who want to criticize corporations or moneyed individuals, and whether every time you criticize Mineral Resources Sands or Anglo-American or Johan Rupert or any of those people, you must do so knowing that they have enough money to take you to court and to bankrupt you and to keep you in proceedings that will bankrupt you for many years, irrespective of whether their claim is good or not. And that's why, with respect, the debate about the merits is neither here nor there for present purposes. The very point of a slap suit is it's to say, you don't have to succeed on the merits at the end of the day, because it is the trial itself that is ruinous. For my clients, my lady, if these exceptions are upheld and if the special pleas are not permitted, then each of my clients is going to be faced with a choice. Either they're going to have to capitulate and engage in some sort of apology in an effort to make this litigation go away, or they are going to have to engage in extensive litigation, long litigation, against plaintiffs who have, from the relative point of view of my clients, infinite resources. Now, my learned friend, Mr. Hodis, says, well, they're not huge multinational corporations. Well, my lady, compared to my clients, whether they are only national, multinational, large, medium, or small, it's irrelevant. The point is that we are engaged in a situation where, if, as my clients contend, this is litigation that is brought just for purposes of silencing the defendants and the public and intimidating them, if the special pleas are not upheld at trial, and I'll come to how the procedure works, my clients are going to be sucked into extraordinarily lengthy litigation. And whether they are even able to do that litigation will depend entirely on whether they can get pro bono assistance from lawyers and counsel. To today already, my lady, we sit here where the only reason that we are in front of you is because the attorneys and counsel have agreed to act pro bono, or in the case of the junior, on reduced rates. There has already been a substantial costs award in favor of Mineral Sands Resources against Riddell and company. That costs award is in relation to a discovery fight. That costs award is having to be dealt with.
Yeah.
And the point is, it's one thing to say, come and defend on the merits, where everyone will have a fair shot at it and where everyone will be able to afford it. But what slap suits are about, and perhaps more importantly, what abusive process is about, is when people come to court not to vindicate their reputation, but instead in an act of interorum litigation, an attempt to silence not just these litigants, but the others. Because, my lady, could you take a moment and pretend not that you are Ms. Riddell or Ms. Davies, but you are the next lawyer at the Center for Environmental Rights. And you are invited to give a talk at the summer school. And you are asked about the behavior of Mineral Sands Resources. What are you going to say, my lady? The odds are that you are going to self-censor yourself, or reduce what you say, or cut down what you say, or avoid it entirely, because you know that the moment you criticize them and step out of line, you're likely to be hit with a defamation suit of this type.
Can you pause one moment?
Of course.
When I read the statements allegedly made, I was concerned when I saw the word bribe.
Yes.
And let me just see, exploitation, license, the killing, I saw the word killing.
Yes.
Where must one draw the line
Well,
in terms
my
of
lady,
language that is used when you do your presentation?
yes. My lady, let me say that is a good question with respect, and it's an important one, but it is a difficult question, and it's not one that has to be answered in this case. And let me explain why. We are not asking your ladyship to find that those statements were true, that those statements amounted to protected comment, that those statements amounted to reasonable comment. That will be a matter in due course for the trial court on the merits, if we get there.
Yes.
But we are saying something else. We are saying that the law recognizes and ought to recognize a situation where when you come to sue someone who accuses you of exploitation, you must come to vindicate your reputation, and then you can come to court and you can proceed. But if you come to court not to vindicate your reputation, but you come to simply terrorize everyone into never criticizing you again, that is impermissible. So with respect to your ladyship's concern is a good one. There are things that can be said lawfully and there are things that can be said unlawfully. But we're not debating today whether what was said lawfully or unlawfully. We're debating whether the mining companies can come to court in an effort, as pleaded, and I'll take you to what's pleaded, in an effort to intimidate people into not saying things again. And let me use the word that your ladyship used, exploitation. It's a harsh word, my lady. It's a very critical word. But where are we going to be in our society, in our constitutional democracy, if every community activist who wants to say Anglo-American is exploiting the workers is faced with ruinous defamation suits? The need for people to be able to make those comments is important. And just as community activists have the right to say it, Anglo-American has the right to counter it. They have vast PR resources. They have vast resources to counter it. So we are not debating today whether these comments are permissible or impermissible. But what we are saying is that if every community activist or every lawyer or every environmental activist faces the threat of damages claims like this the moment they criticize a company, then there is a real problem in our constitutional democracy.
But in a slap suit, it appears that the merits would still be relevant.
Well, with respect, my lady, that is the regime that has been created by means of some of the statutes overseas, and I accept that.
Yes.
But we're in a different world. We're in an abusive process. And that's why, and it's the very next point I was going to make to your ladyship by way of outline, is with respect to your ladyship mustn't be distracted. Your ladyship has been taken left, right, and everywhere, partly by the amici, who I know are our friends, and they are our friends. But I must say, your ladyship mustn't lose sight of the core issues. The core issues in this case, are firstly, do courts have an existing power to stop abusive process on the basis of impermissible purpose? That's the first question. If so, is seeking to silence and intimidate defendants or the public a permissible purpose? And we say it's plainly not a permissible purpose. And thirdly, if needs be, does the common law have to be developed to allow for the defense? And we say it does. Now, that doesn't mean that your ladyship is creating something identical to a slap suit defense. Your ladyship is simply applying the existing common law rules which relate to abusive process. And so it's true that many countries require a consideration of the merits in relation to a slap defense. But we have pleaded something specific, and that's where I want to take your ladyship. Because this is an exception. And the exception is not taken in the air, it's taken to a specific pleading. But what is remarkable is that throughout the address of our learned friends, Mr. Hodis and Mr. Duval, your ladyship has not been taken to what the special plea actually says. What are the facts that are actually pleaded in the special plea and that must be regarded as true? So could I take your ladyship there? Does your ladyship have the Riddell papers to hand?
Yes.
And if it's not convenient, we've actually quoted it in our heads of argument, so it might be easier to go there.
Yes. Oh, okay. I'll stick to your heads then.
Thank you. If your ladyship has regard to page 6 of the heads, we deal there with the first set of special pleas and exceptions. And we emphasize in the special pleas that the mining company's claims are brought against individual defendants. And we emphasize that the claims are brought even though there's no allegation of patrimonial loss, that there's no allegation that the statements are false, and that the mining companies do not honestly believe that they have any prospect of recovering the amount of damages claimed. So that's the context. And then we plead the following critical allegation, my lady. And if your ladyship would emphasize that, make a note.
Yes.
The plaintiff's action is brought for the ulterior purpose of discouraging, censoring, intimidating, and silencing the defendants in relation to public criticism of the plaintiffs. And so again, the plaintiff's action is brought for the ulterior purpose of intimidating and silencing members of civil society, the public, and the media in relation to public criticism of the plaintiffs. Now, my lady, those are factual allegations. For purposes of this exception proceeding, they must be accepted as true. Whether they are true will have to be determined in trial in due course, but for present purposes, they must be accepted as true. And then you go on. We plead in the special pleas that the plaintiff's conduct in this regard forms part of a pattern of conduct by the mining companies, and that this pattern of conduct involves bringing defamation actions for the ulterior purpose of discouraging, censoring, intimidating, and silencing the defendants and civil society. Now, my lady, those are extraordinary allegations. It's not just that the plaintiffs are trying to silence the defendants, they are trying to silence the world. It's not just that the plaintiffs are trying to silence the defendants in relation to this criticism, the allegation of exploitation or the allegation that the cliff collapsed because of MSR. They are trying to silence public criticism in general from the defendants or the public. Now, whether that is true or not will have to be determined in trial. And the defendants will have to get into the witness box and they will have to explain, no, they will say, I didn't intend to silence them. I was just seeking to vindicate my reputation. And they will be subject to cross-examination on that score. But for present purposes, your ladyship has to accept, and everyone accepts this, that this is true, that it is true that this action is brought for the purpose of discouraging, censoring, intimidating, and silencing the defendants and civil society and the public and the media, and that this is part of a pattern of conduct. Now, my lady, if that is true, then there's no need to even look to the merits, because this is the clearest case of a slap suit imaginable. In some situations in the world, it's true that one looks to the merits, but that's because the threshold for a slap suit is much lower than this. You don't have to show that that's the purpose. There are all sorts of thresholds. But in this case, on our common law, we say this is more than enough. And you don't have to get to the merits, because if you got to the merits, the whole point of this kind of abusive process defense would be undermined. The point of an abusive process defense is to allow the defendant to say at the outset, this case should be terminated, because to even put the defendants to the trial will produce in the very discouraging, censoring, intimidating, and silencing that the plaintiffs are seeking to achieve. And I demonstrated that to your ladyship at the beginning. If this special plea is rejected, then we will have to get to the merits of the trial. And that will produce precisely the censoring and silencing effect that we had anticipated. Because every activist and every environmental lawyer who thinks about criticizing MSR will say, well, I'm not prepared to be sucked into a 5-year piece of litigation, which I have to pay for, or which I have to try and raise funds for. It will be a distraction from my work, and I'd rather go and criticize someone else. And then the purpose of the slap suit, which is what it is, has been achieved. So we say, my lady, it's notable that our learned friends don't go to the facts. And that's because the facts, as pleaded, are so damaging for them. Indeed, our learned friend, Mr. Hodis, referred your ladyship to a US case, saying that the facts must be pleaded, and told your ladyship you would find very few of those here. But with respect, he didn't even go to the facts, and those facts speak for themselves. And let me say again, my lady, it is common cause, as it always is, that in exception proceedings, your ladyship must accept the facts as pleaded to be true. That is trite law. We've given you the we've given you the law in our heads of argument at paragraph 21, but our learned friends seem to accept it. So those facts must be taken as true. The last preliminary point I wish to make, my lady, before delving into the substance, is that your ladyship is asked, or your ladyship has been taken to long debates about freedom of expression versus dignity. How do you rank them? How do you balance them? You've been told about the role of access to court. But with respect, those arguments tend to obscure the real issue. We accept that plaintiffs, including these plaintiffs, have a right of access to court under Section 34. And we accept that a proper balance needs to be struck between dignity on the one hand and defamation, although of course the debate about dignity will depend on SA taxi, but we accept that a balance needs to be struck. But we're not debating that today. We are debating what the law says when a plaintiff abuses its rights under Section 34 and abuses its rights under the law of defamation. That's where we are. So we accept that the plaintiffs have a right to bring litigation under Section 34 and they have a right to sue under the common law of defamation. But the question is, what happens when instead of using those rights for the correct purposes, vindicating their reputation, they use them in order to censor, intimidate, and silence all public criticism of them? And we say that that is an abuse of rights. It renders this an abusive process, and on that basis alone, this court is entitled to strike it out, if that is proved at trial when we get there. But what the plaintiffs seek to do, and it speaks volumes, the plaintiffs ask you to dismiss this defense today without even hearing from the witnesses. And the reason must be obvious. They don't want their CEO to have to get into the box and explain why it is that they've decided to sue 3 activists and 3 lawyers who have no money and will never be able to pay this. They don't want to have to explain it. And so they seek via these exception proceedings to cut off that defense at the knees and make sure we never get to court. And let me make one last point on the procedure in that regard. Our learned friend, Mr. Duval, says, and I think my learned friend, Mr. Hodis as well, said, but the trouble is that you're going to have to go through the whole trial to get there. Of course you won't, my lady. Your ladyship knows all too well that Rule 33.4 provides for separation. If your ladyship dismisses these exceptions, the mining companies will have to plead to the special pleas, and my clients will then apply for separation. And every court in the world would grant that separation, because they will say, we'll grant the separation, fight the special plea first, and then if the special plea succeeds, that's the end of it. If the special plea fails, then we get to the merits. So this notion that my clients are seeking to engage in the lengthy trial is of course not true. My client's whole proposition is that the lengthy trial is a facade and an attempt to tie them up in expensive litigation for years. They seek via these special pleas to have this adjudicated, and they will in due course seek to have it separated in terms of 33.4. If the trial judge hearing this special plea is not satisfied that this was the purpose, then the trial judge will dismiss the special plea and my clients will have to bear that. But if the trial judge is satisfied, having heard evidence and cross-examination, then the trial judge will uphold the special plea and the cases will end there. And that's all my clients seek to achieve. But what the plaintiffs, what the mining companies want to do is prevent us from even getting there. They ask you to reject it out of hand, but they can't. And they can't because on our existing law and as our law is developed means that if you accept as true, as you have to, that this is action that's brought for these ulterior purposes, it is impermissible and it falls within the scale of an abusive process. My lady, I'm now about to delve into the substance of the address. I see it is 3 minutes to 1. Is it convenient? I'm happy to begin, but if your ladyship is about to take the lunch adjournment, perhaps this would be a convenient time.
What time will we get back?
I think your ladyship suggested half an hour, so perhaps we could resume at 1:30.
Yeah, sure. We will then adjourn until 1:30. Thank you very much.
Thank you, my lady. And is Lerato on?
We still have time, it's fine.
There's Lerato. Okay, good. I think that's everyone. Thank you, my lady.
Yes.
My lady, before the adjournment, I had urged your ladyship not to be distracted by the best intentions of our friends for the amici and
yes,
by the less best intentions by our friends for the mining companies, and to focus on what are really quite narrow issues. And I had said that there were 3 issues. There was the question of whether the motive is relevant in the context of abusive process under our law. There's the question of whether seeking to silence and intimidate defendants and the public is an impermissible motive or purpose. And thirdly, whether the common law falls to be developed. I'm now going to turn to deal with each of those 3 issues, my lady, if I may. And I will add just one brief 4th issue, and that is the question of this last-minute complaint that we followed the wrong procedure. And I'm just going to spend a moment on that, because with respect, it's just a point that shouldn't detain your ladyship for more than 30 seconds, but I'll come there at the end if I may. So we begin with the question of whether motive is relevant. And again, if I could ask your ladyship to have in front of her the heads of argument which we filed. And we begin at paragraph 24 on page 10.
Right, I'm with you. Thank you.
Thank you. And what we then proceed to do is we proceed to highlight, firstly, the Lawyers for Human Rights cases of the ConCourt. And at 24.2, we make the point, or 24.1, we make the point that the Constitutional Court, now speaking, has held that there can be no doubt that every court is entitled to protect itself and others against an abuse of its processes, and that it quoted long-standing authority to the fact that when the court finds an attempt made to use for ulterior purposes machinery devised for the better administration of justice, it is the duty of the court to prevent such abuse. Now, I'll come back to my learned friend's attempt to distinguish it, but could I just emphasize, one of the forms of machinery devised for the better or proper administration of justice is the courts and the court processes and action proceedings. And so we submit that it's obviously where we are at the moment. But I'll come back to the attempt to distinguish it in a moment. But then what our learned friends seek to rely on very heavily is the Mapanga decision. And we address the Mapanga decision at paragraph 28 and follow. And can I just say where we agree with our learned friends and where we disagree with them? It is absolutely true that they're correct. Mapanga makes no reference at all to the question of motive or purpose. The passage which they refer to doesn't speak of it, and the passage they refer to is indeed cast in broad terms, and we accept that. But the question is whether that means that the SCA was deciding as a ratio, which is what they have to try and urge, as a ratio that motive or purpose had no place. And we respectfully submit that that is not the effect of the judgment at all, because the motive and purpose simply wasn't at issue in those proceedings. There is no reference to the motive or purpose. So we accept that Mapanga, read on its own, might suggest that the common law doesn't take account of motive or purpose. But as I've explained, the improper motive of Mr. Mapanga was never raised. All that was at issue in that case was whether his claim was obviously unsustainable. And so that's all that the court dealt with. It was dealing with the test for obvious unsustainability. So there the court was saying, the claim is prescribed. There's no point in allowing a trial because the claim is obviously prescribed. It's obviously unsustainable. So we say that Mapanga simply doesn't answer this question. At the very least, it doesn't answer the question as a matter of ratio, because even if the court had said something about motive, it would have been arbiter. But more importantly, my lady, we make the point at paragraph 29 of our heads that if Mapanga did purport to decide that motive or purpose was irrelevant to debates about abuse of process, that would have been extraordinarily surprising. And that is because we have drawn your ladyship's attention to no fewer than 8 separate authorities where the courts have regarded purpose or motive as being relevant to abuse of process. I think it's 7, in fact, 7 separate authorities. And we have drawn your ladyship's attention to the fact that these include decisions of the Constitutional Court and the SCA. Now, what is our learned friends, and we've summarized those at 29. So we speak about in 29.3, Phillips versus Buerta, the SCA saying abuse of process means employing the process for some purpose other than the attainment of the claim in question. If the proceedings are merely a stalking horse to coerce the defendant in some way entirely outside the ambit of the legal claim upon which the court is to adjudicate, they are regarded as an abuse for this purpose. Now we say that's exactly where we are. These are not proceedings which seek actually to obtain damages. They are proceedings as pleaded, which seek to silence not just these defendants, but the public from criticizing these plaintiffs. And any public criticism, not just about this particular cliff or that particular killing or this particular bribe, anything. And so the SCA endorses that abuse, that definition from an Australian decision, and goes on to say, where the court finds an attempt made to use for ulterior purposes police machinery, it's the duty of the court to prevent such abuse. So we have given you these multiple examples of what the courts say on that score. And what is the answer from our learned friend? Well, the answer from our learned friend, Mr. Hodis, is that these cases are all distinguishable in relation to what factual situation confronted the court, or what issue confronted the court. So he, for example, distinguishes LHR as being on the basis that it was about costs. And he distinguishes Bainash as being about subpoenas. And he distinguishes Phillips versus Buerta as being about private prosecutions. And he distinguishes Roaring versus Mahlangu as being about cross-examination, and Goldfields versus Motley Rice as being about champer disagreement, and Ascendus of the Constitutional Court as being about the raising of defenses. Now, we understand that proposition, and we accept that none of those involved an attempt to quite strike out a claim in this way. But with respect, our learned friend's argument gives rise to a very surprising and we submit unsustainable conclusion. He wants you to hold that abuse of process means one thing when it comes to costs, subpoenas, cross-examination, private prosecution, champer disagreements, raising of defenses, and something else entirely in this case. In other words, it means one thing consistently across all of those 6 scenarios. Motive is always relevant. And yet somehow in this case, where you try and raise it as a defense, he says, purpose is not relevant. My lady, that's an extraordinary proposition, because why should abuse of process mean something different in this case and in this situation than it does in every other situation in the law where abuse of process has been dealt with? We couldn't find examples, and our learned friends haven't put up examples where abuse of process was held to exclude that. The most that they do is to rely on cases like NDPP versus Zuma and Beckenstrater and Sose, which were criminal cases where the court said in NDPP versus Zuma, a prosecution by the state is not unlawful merely because it was actuated by ill motive. Now, there might be all sorts of reasons that that's different, but whatever the reasons it's different or not, that's not where we are. We're not in a prosecution sense. And so your ladyship can put to one side NDPP versus Zuma, and you can put to one side, or Zuma versus the Democratic Alliance, and you can put to one side the other cases relied on by Haram-Stipi, Sose, and Beckenstrater. Those were all squarely in a criminal context. In a civil context, all of the cases we have referred to make clear that ulterior purpose is relevant. And those are the cases to which I've just referred. The only one which is at odds with that is Mapanga. But Mapanga, as I say, just doesn't address the point. So your ladyship is left with a situation where your ladyship has pronouncements from the Constitutional Court, the SCA, and the High Court, all saying that purpose or motive is relevant. One judgment, Mapanga, not dealing with the issue, and then other judgments in a different context, the criminal context. And we say that your ladyship must conclude on that basis that motive is relevant in relation to abuse of process. We don't say motive is relevant in every situation, but when it comes to abuse of process doctrine, motive is squarely relevant. And really, there's not much more to say on that first point. Lastly, let me say, and I'll come to it, even if your ladyship was somehow to conclude that our law has this very weird divergence, whereby motive is relevant to costs, subpoenas, cross-examination, private prosecution, champer disagreements, and raising of defenses, and yet it's not relevant to abuse of process in this context, then we say that your ladyship should develop the common law as we've articulated. But we say your ladyship doesn't actually get there because the common law already accommodates it very adequately. So that's the first point, the first question I asked, and with respect, the answer that we give, and we persist with that answer. And we say that Mapanga is certainly no objection to that for the reasons that I've articulated. That then takes us to the second question, and the second question is this a permissible motive? In other words, if you go back to what was pleaded in the special plea, this motive or purpose of seeking to censor, intimidate, and silence the defendants and the public and the media in relation to public criticism, is that a permissible motive? Now, In their heads of argument, our learned friends don't really grapple with that. They don't explain why it's permissible. And that's unsurprising, because I would have thought it's obvious that it's not. But in this case, or in this argument, the oral argument, they did seem at times to suggest that this might be a permissible motive. They didn't squarely address it, again, for understandable reasons, because it seems almost unarguable. But they began to say, our learned friend, Mr. Hodis in particular, began to suggest that it was somehow desirable to allow these lengthy trials, if necessary, rather than deal, rather than cut the matter off. And he gave your ladyship one striking example, which I'd like to spend a moment on. And that is the example he referred to of McDonald's versus Steele and Morris. Now, that was the McDonald's case that he referred to. And indeed, as he correctly made the point, that was a case which ran for 10 years in the English courts. In a case between McDonald's, on the one hand, one of the largest corporations in the world, and two environmental activists who had criticized McDonald's and its practices. And our learned friend said, or seemed, unless we've misunderstood him, to suggest that that was the way the world should work, that it was a perfectly appropriate way of litigation running, that you should have this trial for 10 years with a giant multinational on the one hand and two individual litigants on the other, desperately trying to save their position. Let me say, my lady, if that is the submission, it is an extraordinary one. Because the McDonald's versus Steele case has become known colloquially as the McLibel case. McLibel as in libel and defamation. It is known world over, even on Wikipedia, as the McLibel case, because it is the classic example of a slap suit. It is the classic example of a multinational corporation using its power to litigate for money that it could, it didn't worry about the silks and the Queen's Counsel it was briefing against these two environmental activists for 10 years. And it's not just me or Wikipedia saying this, it's the European Court of Human Rights, because the sequel to this 1,000-page judgment that our learned friend referred to in the McDonald's case, the sequel to that was a decision of the European Court of Human Rights in the matter of Steele and Morris versus the United Kingdom. Because what happened was Steele and Morris took that case, or took their experiences in that case, to the European Court of Human Rights and said that the United Kingdom system of law violated their rights because it allowed them effectively to be censored and precluded from stating things about McDonald's, and that it didn't give them any form of equality of arms. It didn't give them any form of funding. And we will make available to you, when the hearing is concluded, the European Court of Human Rights judgment, not because it calls it a slap suit, but because the same principles are the same sort of approach is articulated. A profound concern by the European Court about what was allowed to transpire. And it went so far that the European Court, in fact, held that the United Kingdom had denied Steele and Morris a right to a fair trial. They'd breached the European Convention on Human Rights in that regard, and that their statements had been protected by Article 10 of the European Convention, which protects the right to freedom of expression. And the court awarded a judgment of £57,000 against the UK government. So with respect, if McDonald's versus Steele is worth anything in this case, it is authority for the proposition, or at least it supports the logic of our case, which says that our country, which values freedom of expression, which values equality of arms, and which values criticism of corporations where necessary, could never allow a McLibel case. And yet the approach that the plaintiffs urge would do exactly that. The plaintiffs say, even if they are like McLibel, even if they are bringing this for ulterior purposes, they are entitled to run this case in the Western Cape High Court for the next year or 2 years or 3 years or 4 years. And the fact that that results from a desire on their part to silence these defendants and silence the public is fine. That's perfectly consistent, they say, with our law and abuse of process, and perfectly consistent with our constitutional scheme. We say, with respect, quite the opposite is true. And similarly, the example given by our learned friend of the pharmaceutical company, our learned friend gives the example of a pharmaceutical company who says that they've got a good reputation, and yet there are some activists who simply will not stop about how they are. doing something dastardly. Well, my lady, the remedy then with respect is obvious. If they've got a true case for an interdict, they go for an interdict and they must meet the test. And our learned friend says in that regard, well, he says, well, they couldn't have got an interdict in this case because the harm had already been suffered. But with respect, that's quite wrong, of course. It's true that an interdict is not a remedy for past infringements, but what always happens, and I see this day in and day out in the cases I do, both for those who defame and those who are defamed, is that what happens is you complain. If I defame Mr. Duval, Mr. Duval gets an attorney to write me a letter saying, you said scurrilous things about me. Undertake that you will not repeat them, or I will seek an interdict against you. And then the interdict follows. And then the interdict is either granted or not granted, but there's a very high threshold that must be met because of the print media case and MIDI television, which say it's a drastic interference with speech. So if the problem is a pharmaceutical company, as our learned friend suggests, then the remedy is obvious. Let them go for an interdict. And if they can get an interdict, then they're entitled to it. And if they can't, then they're not. But what they cannot do is what they've done in this case, which is to seek to obtain an interdict via the back door. They don't seek an interdict at all. And instead, they launch this litigation for the purpose of effectively getting an interim interdict via the back door for the purpose of, as was pleaded, silencing, intimidating, censoring criticism, not just, again, by these defendants, but by the world. And again, that is the fact that you must accept as true. So we say with respect that the two examples given by our learned friend both cut against him quite palpably. And we persist in what we say in our heads of argument, and we deal with this in the heads at paragraphs 31 through all the way through to 43. Could I just emphasize a couple of points just to bring them home? The first point we make is that it might be different, and I don't want to accept that it is, but it might be different if this was just one case in isolation. Perhaps then a court would be slower to accept that this is impermissible. But of course, what we've pleaded as a fact, and what must be accepted as a fact, is that this is part of a pattern of conduct. That's paragraph 4 of the special plea. And it's that pattern of conduct whereby the plaintiff seeks to intimidate not just the defendants, the named defendants, but also civil society, the public, and the media. And that's a very important facet. We have drawn your attention to statements about the importance of freedom of expression, but that doesn't really take us much further than the debate has already happened, and your ladyship is well aware of that. We've drawn your attention to the principles about how an order preventing defamatory matter is a drastic interference with freedom of speech and should only be granted when there's a substantial risk of grave injustice. That's paragraph 36, relying on the judgment in MIDI television of the SCA and print media. But it's important just to remember why the courts say that. And we make the point at paragraph 36 that the reason that the courts are so worried about it is because an order against one person preventing them from speaking about something doesn't just affect their rights. It affects the constitutional rights of the public to receive that information. So if I get an interdict against my junior Ms. Kazi to stop her from defaming me to members of the bar, then she is prevented from speaking, but the members of the public, the members of the bar are prevented from receiving that information as well. And that's why the courts are so slow to grant these such interdicts. But what that means in turn is that to come to court on a purported damages claim, when you know you will not be able to get the money back, and instead of seeking to vindicate your reputation, what you're actually trying to do is silence criticism, is palpably in breach of the right to freedom of expression under the Constitution. We then make the point in paragraph 38, which just bears emphasis, that much of this case takes place in a debate about environmental compliance and environmental law. And that is very important because we've drawn your attention to the decision of the SCA, and I note my learned friend didn't deal with it, but in the decision of the SCA in ArcelorMittal, the court explained the value of public participation and the value of citizens engaging in these sorts of debates. And the SCA, the quote in paragraph 38.1, speaks about the fact that citizens of the world are growing alert to the dangers of a culture of secrecy and unresponsiveness, both in respect of governments and in relation to corporations. And in South Africa, because of our past, the latter aspect, that's corporations, has increased significance. Now, let me say, ArcelorMittal was a PIA case. It wasn't a damages claim. It wasn't defamation. But the principle is enunciated is absolutely clear. It's a need for the courts to avoid a situation which promotes secrecy and unresponsiveness in relation to corporations. And then over the page at 38.2, we quoted the judgment of the same judgment of the SCA, making clear that environmental degradation affects us all. Well, let me go back. It spoke about the importance of consultation and interaction with the public. Environmental degradation affects us all. One might rightly speak of collaborative corporate governance in relation to the environment. Well, my lady, I would ask rhetorically, how can one have collaborative corporate governance and interaction with the public if members of the public know that the moment they criticize mineral sands resources, they face the risk of a ruinous defamation suit? How can that possibly promote the idea of collaborative corporate governance and consultation and interaction with the public? And then, of course, the SCA concluding, and we quote this at 38.3, corporations operating within our borders, whether local or international, must be left in no doubt that in relation to the environment, in circumstances such as those under discussion, there is no room for secrecy and constitutional values will be enforced. Again, we say that supports strongly the contentions that we have advanced and demonstrates that the court could never, with respect, a court could never say, and we invite our learned friends to indicate whether they say this is a permissible motive. We invite them squarely to do so. Do they say it is a permissible motive in litigation to bring it for purpose of silencing, intimidating, and censoring the defendants and the public and the media in relation to public criticism? We invite them to indicate in reply whether they say that's a permissible motive. If they don't say it, that speaks volumes. If they do say it, they're plainly at odds with the gist of ArcelorMittal in the SCA. Lastly, in that section, we refer to the Jamil case, and we make no apology for doing so. Jamil, it's the judgment of Baroness Hale, who spoke about the power wielded by multinational corporations. And with respect, the power wielded by multinational corporations is obviously enormous and growing. And the point that Baroness Hale makes is we all become very precious for good reason when we are told we can't criticize government or when there's a suggestion that we can't criticize government. But what Baroness Hale says is that the freedom to criticize corporations may be at least as important in a democratic society as the freedom to criticize the government. That's the point she makes. And it's a point of considerable importance. And that's the context, my lady, I want to draw your attention to what is said in Laugh It Off, because we emailed Laugh It Off to you, and I know your ladyship received it. And if I could ask your ladyship to go there, if your ladyship has it to hand, otherwise your ladyship can just make a note. I can read it to your ladyship, there's no difficulty. But Laugh It Off, your ladyship, as my learned friend rightly pointed out, was about freedom of expression in the context of trademarks, and it did make clear that freedom of expression in our society is not absolute, and nothing we argue here is about absolute rights. But what I wish to draw your ladyship's attention to is something in the passages. Your ladyship recalled that there'd been a judgment of Justice Sachs, a concurring judgment. And yes, I wish to draw your ladyship's attention to that. It's at paragraphs 103 and following. And there, does your ladyship have that?
No, I don't have it, but you...
No, not at all.
Yeah.
I'll read it to your ladyship, and if your ladyship would simply make a note. It's paragraphs 103 to 106 of Laugh It Off. And there, Justice Sachs was debating a parody defense and the right to make jokes and various things. Yes, but yes, he then said the following. He said, I would like to add two considerations of special constitutional significance, which I believe reinforce the conclusion to which I've come. And the first relates to the chilling effect that overzealously applied trademark law could have on the free circulation of ideas. And he then goes on to explain that he accepts that litigation could sometimes be a risky enterprise for a meritorious trademark owner, as well as the prankster. And he makes the point that, you as a business, you might have everything thrown at you, and so there are some risks. But he then says, and this is the critical passage at 105 to 106, he says, of more significance from a constitutional point of view is the manner in which even the threat of litigation can stifle legitimate debate. I just underline that. It's the threat of litigation. Large businesses have special access to wealth, the media, and government. Like politicians and public figures, their trademarks represent highly visible and immediately recognizable symbols of societal norms and values. The companies that own famous trademarks exert substantial influence over public and policy issues. And then he carries on at 106. Yet when applied against non-competitor parody artists, the tarnishment theory may, in protecting the reputation of the mark's owner, effectively act as a defamation statute. As such, it could serve as an over-deterrent. It could chill public discourse, because trademark law could be used to encourage prospective speakers to engage in undue self-censorship to avoid the negative consequences of speaking, namely to be involved in a ruinous lawsuit. If your ladyship will forgive me, I'm going to read that sentence again. It could chill public discourse because trademark law could be used to encourage prospective speakers to engage in undue self-censorship to avoid the negative consequences of speaking, namely to be being involved in a ruinous lawsuit. The cost could be inordinately high for an individual faced with a lawsuit aimed at silencing a critic, not only in terms of general litigation expenses, but through the disruption of families and emotional upheaval. Such a protracted vexation can have the effect of discouraging even the hardiest of souls from exercising their free speech rights. Lady, with respect, that is exactly our point. This litigation brought for this purpose is trying to achieve exactly the form of self-censorship that Justice Sachs was warning against. Because what it means is that people can only speak at the risk of being engaged in, as he calls it, a ruinous lawsuit. And he says that can have the effect of discouraging even the hardiest of souls from exercising their free speech rights. With great respect, I can't put it better than that. That is the exact point. Now I accept, of course, that this is in the separate concurring judgment. It's not, but that doesn't matter. The principle speaks volumes. So what we say, my lady, is when you answer the second question, and the second question is this a permissible purpose? Well, obviously it's not. And so where are we, my lady? We're in a position where we say we've demonstrated that motive is relevant, and we've demonstrated, that's the first question, and we demonstrated the second question, that this is an impermissible motive or purpose. And your ladyship must accept that this is the purpose because we're in exception proceedings. On that basis alone, the exception falls to be dismissed, and the matter must proceed to trial. And we will in due course seek a separation, and then the CEOs and the directors can get in the box and try and persuade the court that actually they weren't trying to silence their critics at all. They were just trying to vindicate their reputation. And we can have that debate, and we can deal with it. But the suggestion that we should be stopped at exception stage, we submit is quite wrong. That leaves us to the third matter, and the third matter we have dealt with in paragraphs 44 and following, which is the development of the common law. I'm not going to spend long on it, my lady, because we've really argued it and we've explained why. I hope your ladyship has heard the argument about why it's essential that our law does this. We say our law already does this. But if for some reason our law doesn't do this, then your ladyship is entitled and indeed permitted to develop the common law in terms of section 39(2). We say that's more than adequate, whether you're under 39(2) or 173. We've drawn your ladyship's attention to the tests as recently enunciated in the MEC for Health versus DZ. And we've explained to your ladyship that we don't urge your ladyship to rewrite the law or write a statute. All your ladyship would be doing is an incremental development of the common law to say it does apply to this sort of a situation. We've got a law, we've got a common law which allows for abuse of process. We've got a duty of the courts to stop it. And if the law doesn't already cover this, it would be developed into that. So it's the very kind of incremental development of the common law which we say is what is warranted. And we've then drawn your ladyship's attention to the examples of foreign courts and foreign acts. Again, we don't say that your ladyship should slavishly follow those. On the contrary, all we're trying to demonstrate to your ladyship is that this concern that was articulated, we've now discovered, and we hadn't seen it before, in Laugh It Off, this concern is a very real one all over the world, and your ladyship should be mindful of it in developing the common law. And then the last point on the development of the common law that we make is the point at 54.3, because there's a lot of criticism to say, well, how can you do this under the common law? Shouldn't Parliament have done it? And maybe Parliament should have done it. But we've given your ladyship the example of class actions. Class actions should have been done by statute. Every other country in the world of which I'm aware that has class actions has a statute. But when the case arose in the bread consumer price, the bread consumer case, that's the Children's Resource Centre Trust, the court didn't shy away and say Parliament should have done it. They said Parliament should have done it, but we have to do something to vindicate the Constitution. And we submit that that is precisely what this court ought to do. So, my lady, we say that of those three questions, firstly, the law does allow motive to be taken into account under abusive process. Secondly, that this is an impermissible purpose or motive. And thirdly, if necessary, the law can be developed. That leaves only one other point, my lady, and that is the question of the contention that the wrong procedure was followed. That is relying on the decision in Jorgensen. But, my lady, there's a short answer to that proposition. And that short answer is that was not a ground of exception. If our learned friends contended that it was a permissible ground of exception, that should have been a ground of exception. It was not. And so to suggest that this point had to be taken by way of application rather than by way of special plea, we submit is not available to the defendant, to the plaintiffs at this point. They simply didn't take the point. But could I say, it's revealing, of course, why they want that. They want us to go by way of application, so that we are in a Plascon-Evans world, so that we are the applicant and they are the respondent, and their CEO will give an affidavit and he will not be subject to cross-examination. That's why they want to take the Jorgensen point at this last gasp measure. We say no, my lady. We say we do anticipate a dispute of fact on this issue, and we are entitled to refer it to trial in the ordinary way, and we're entitled, given that we're in trial proceedings, to proceed by way of a special plea. But in any event, I'm not going to debate the merits of Jorgensen or not with you, because they didn't take the point in their exception, and it's too late to do so now. An exception is a pleading, and they must be held to their pleadings. My lady, that then concludes our argument on the first set of special pleas and exceptions. We accept, as has been indicated, that the second set of exceptions falls to be upheld. And we would simply suggest that your ladyship do so on the basis that your ladyship is bound by SA Taxi, and that will then allow an appeal to the Constitutional Court on that score, which is very much my client's intention. Lastly, on the question of costs, my lady, we're not going to have a lengthy argument about this, because it seems, with respect that at least in respect to the second exception, this is heading to a higher court. But we do just say this. We accept that this is not a BioWatch case because it's between private parties. But what we say is that the disjuncture between Kumalo versus Holomisa on the one hand and Napier versus Barkhuizen on the other makes clear that your ladyship has a discretion in a case like this. And so you could go the Kumalo versus Holomisa route and say, if we lose, we must pay the costs. Or you could go the Napier versus Barkhuizen route and say, if we lose, we shouldn't pay the costs. We submit that it's the latter case that's appropriate. These are profound issues of importance raised by individuals, not by a media company, as was the case in Kumalo versus Holomisa. But in any event, we say your ladyship shouldn't get there, because your ladyship should simply reject the exceptions. And in those circumstances, we would ask for costs awards because we would have successfully vindicated constitutional rights. And so we would submit that the first exception should be dismissed with costs, including the costs of two counsel. And in fact, we would ask for 3 in your ladyship's discretion, given the wealth of the foreign authorities and that both parties have 3. But so the first exception should be dismissed with costs, including the costs of 3 counsel. And the second exception we accept has to be upheld, and we would ask that no costs be awarded, particularly given that no time has been devoted to that issue before your ladyship. I hope the members of my team don't have anything to add. I can't turn to them and ask, but if there is anything, I'll let your ladyship know. But I think that is probably our submissions. Thank you very much, my lady. Those are our submissions.
Will that be all for today? I'm just looking at the timetable here. So we will then proceed tomorrow, 10 o'clock, with the amici. Is that correct?
I think there was some suggestion that the amici might come on today, but I will leave that to your ladyship and the amici to debate. So that certainly is, those are our submissions.
No problem. I'm happy to hear them if they are prepared to argue today.
I'm here, my lady.
Yes. Hi.
I was actually about to ask for a short break, my lady, before we proceed.
Yes.
But seeing as my lady is prepared to hear us tomorrow, I'm perfectly happy with being heard tomorrow. But I'm with my colleague, or my senior, Anton, and he's representing UCT. Perhaps he has some views in that regard. But yes, I would be happy to proceed tomorrow.
Right.
Yes. My lady, I see it's just 2:05. My personal preference would be to argue now, right now, if with your ladyship's leave. It would be easier to prepare my argument having just listened to Mr. Hodes and Mr. Duval this morning. That would be my preference.
Yes. I'm happy to hear you now. I have no problem if we proceed.
Okay.
And then Perhaps tomorrow we can do the reply, but as long as you know you do have an option, because we probably will come back tomorrow.
Yes, thank you. But Malene, I'm happy also to go before Kel's, just because she needed a break. So I'm happy to go now, and maybe she can, Ms. Foster can, it's up to her, but I'm happy to go right now.
Is she, Ms. Pasha, are you happy that Advocate Katz continue?
My lady, I have no issue. Our submissions differ. Quite frankly, it would not necessarily impact on our case at all. So he can proceed, my lady.
Thank you, my lady.
Thanks, Advocate Katz. Just give me a moment.
Yes,
I just need to find your heads.
Well, yeah, my lady, while you're looking for them, the only documents that I'm going to refer to are our heads.
Yes.
Mr. Hodis's heads.
Yes.
And if you have at your hand, our application to be admitted as an amicus. Those are the three documents that perhaps
Okay.
it would be.
I found UCT's heads, and then it's the applicant's heads. I have Mr. Hodis's heads, your heads. I don't have the application in front of me.
Well, then I'll just refer to it when in my argument, and your ladyship could find it afterwards. And then of course, what's important is the Constitution.
Yes, yes.
And I'd like to start off with two preliminary points before taking the court through our heads of argument. And the two preliminary points are, one, the Constitution, and secondly, what Mr. Hodis's team accepts must be accepted for purposes of this hearing. And in setting out our argument, we support the defendants that in their argument that the exception to the first special plea is to be dismissed. And we make no submissions on costs. And as far as the second special plea is concerned, we have no role to play in that.
Yeah.
So as far as the first special plea is concerned, we would ask that the court first turn to section 16 of the Constitution. And there are two subparts to section 16
yes,
that we wish to emphasize. The first is section 16(1)(d), and that talks to academic freedom and freedom of scientific research. And what we submit at the outset is that when Mr. Naval suggests, yes, science research is covered by academic freedom, but activists are not, he's wrong. And it's clear that when one comes to the actual application for admission as an amicus, that what the activists and the others who were busy at UCT were doing was nothing other than advancing the academic cause. And I'll get to that in a second, but for present purposes, I just want to emphasize that academic freedom is something different to freedom of scientific research. It's wider, and as I'll demonstrate, it goes to the nature of the world that we live in with, in this respect, the environmental struggles that people are experiencing in respect of the particular mining industry. The second part of section 16(1) that I would wish to refer to is the freedom to receive or impart information or ideas. And Mr. Naval seemed to suggest that it was only, let's call it reputed scientists who were doing academic research in scholarly articles who would be covered by the notion of 16(1)(d). But we would suggest that when one has regard to section 16 as a whole, one can't take out the bits and pieces and say, well, freedom of the press, Bogoshi and other media goes into one category, academic freedom in another, and the freedom to receive or impart information or ideas in another. It must be read as a whole. So when a student sits at a university and he listens or she listens and she's receiving information or ideas, we would say, yes, it's a 16(1)(b) right that is at stake, but also academic freedom. So that's the first aspect that we wish to talk to. The second aspect that we wish to talk to, just on this question of section 16(1), is that Mr. Naval seemed to accept, as I understood his argument, that our understanding and our theories on academic freedom was accepted in general, but not for this case. And so, for example, he would say, yes, there is such a thing as institutional academic freedom, that doesn't apply to us. and we would reject his distinction for the reasons that I'll come to when it comes to the facts. But what we say is the institutional freedom and individual freedom are encompassed by the whole of 16.1. And then I want to turn, as a second preliminary point, to what Mr. Hodis's heads talk to, and that is, your ladyship has it, and I'd like to refer in particular to paragraphs 9, 13, and 14, leading up to 15. And what they say, and we agree with them, is that the analysis that this court must engage in and adopt is that the allegations in the plea are true. That's the first sentence in paragraph 9. So then we turn to paragraph 13 of Mr. Hodis's head. He says, on the approach to exceptions, the above-mentioned grounds and the factual conclusion they are pleaded to support that the plaintiffs are acting with an ulterior purpose must be accepted as correct. So your starting point, my lady, is that Mr. Hodis's clients are acting with an ulterior purpose for purposes of today's hearing. Go on to paragraph 14. In these circumstances, the defendant's plea, they say 12.1, the proceedings on abuse of process amounts to the use of court processes to achieve an improper end and to use litigation to cause the defendant's financial or other harm, violates the freedom of expression. Paragraph 15, essentially the defendants contend for an abuse of process. And they say the abuse of process comes from an ulterior purpose, which they accept, the court must accept, as the motive for this suit. And we submit, firstly, that where one has, the court is confronted with an ulterior purpose of the kind that must be accepted for purposes of your ladyship's hearing, it can be nothing other than an abuse of process, which this court will not entertain and allow for a court to be used for an abuse of process. So that's the second preliminary point that I wish to make. In turning to the application for admission as an amicus, in paragraph 51, it is explained, and this is not denied, it is explained that to understand why the defendant's speech in the Riddell matter qualified as academic speech, it is necessary to understand the nature of the course at the summer school and the academic motivation for inviting practitioners and advocates, activists, and lawyers to present the course. And there is a long series of paragraphs from 51 through to 69 which deal with the purposes of the course. And perhaps I should just highlight some of the aspects of it. Paragraph 57, it says the costs of running the course were covered by the National Catalytic Grant from the National Institute for Humanities and Social Sciences. The project was also closely associated with ongoing research funded by a grant from the National Research Foundation titled Race and the Making of an Environmental Public. Professor Green serves as the principal investigator on both projects. And I'll just, with your ladyship's leave, just read the next two paragraphs. The course was presented as part of the field of environmental humanities. Globally, environmental humanities is a fast-growing, transdisciplinary field that aims to facilitate scholarship on human impact on the planet with the goal of supporting the emergence of ecological approaches in collective life, law, and policy. The course introduced environmental humanities in South Africa as a tool to construct conversations of how to think about environmentalism in terms other than the conventional opposition to development with its implied separation of white and black public concerns, working with activists, lawyers and civil societies in a classroom. The conveners sought to trouble the simplistic binary that governs the assumption that development necessarily has to trade off environmental concerns. The goal was to explore in a classroom situation with a range of actors the emergence of black-led environmental movements. And then thereafter, there are a series of movements which are discussed, the Amadiba community struggle in Ponderland. And then the last paragraph in this long series of paragraphs, while it did have the form of a traditional lecture, the course was a core exercise. So while it did not have the form of a traditional lecture, the course was a core exercise of the right to academic freedom and a central part of advancing the academic project. Both in its content and its form, the course sought to interrogate and advance knowledge about the world. It sought to both transmit and to build existing knowledge in an important and relatively new area of academic inquiry. So in summary, what we say is a suggestion that the course that the Riddell 3 took part in was not part of an academic freedom process must be rejected. And we say it's hard for us to understand why the plaintiffs would take such an approach. And I'd like, with your ladyship's leave, to just emphasize, it's not only scholarly activity, writing of a science journal about microbes or other that is covered by academic freedom. It's the whole gambit of how human existence relates to each other. And one looks at the whole range of what's happening with the COVID pandemic, one would just wonder how it could be suggested that the kinds of HIV research that was done in the 80s and 90s or 2000s can't be regarded as part of academic freedom. So we submit that it's an objective, abstract question based on the pleadings, and certainly what happened in our case cannot be anything other than an exercise of academic freedom. And just to round off that point, on the chilling aspect, on the institutional aspect, the lecture didn't happen just in 2017 on a particular day in January. The UCT had to just think they were preparing a course, and in preparing the course, should they have thought, well, we're only going to invite professors and lecturers, because if we invite activists, or if we invite practitioners, whatever those words might mean, then when those practitioners and activists come to UCT and come and give a lecture in this new interdisciplinary world, they won't be covered by academic freedom. And were they to have to even think about such a eventuality, we would submit that that would be a chilling effect on how an institution such as UCT should go about its business, which is new ideas in a new world. So we would submit that the whole process that leads up to that lecture in 2017 is covered by the notion of don't chill. And if I may just turn to our heads, in our introduction, we make the point that I've just gone through in paragraph 5. We say, working with activists, lawyers, and civil societies in a classroom, UCT sought to explore the emergence of Black-led environmental movements. And we say the course considered a range of deep questions that have ironically become central to the current litigation. Whose environment? Who gets to speak? What propositions about the natural and the human undergird scientific advice on governance and management? How do specific forms of evidence become hidden and therefore invisible in situations where corporates and government officials try to push development projects through despite opposition? What strategies are available to researchers to deal with the occlusion of evidence? So that's the genesis of the invitation, which we see in paragraph 7 of our heads. Then with common cause, in paragraph 9, UCT's interest is in the protection of academic freedom. It seeks to protect its staff from future defamation claims for what they or their guests say during lectures as part of an academic project. And we turn to the introductory ideas, which it doesn't seem that Mr. Hoders and Mr. Duval have any difficulty with. The basic idea of academic freedom is simple and unanswerable. Knowledge cannot be advanced unless existing claims to knowledge can, with freedom, be criticized and analyzed. It goes without saying, with respect, my lady, that one doesn't advance in knowledge without the current knowledge or the current state of knowledge being tested, criticized, and analyzed. For the project the academic project to succeed, academics and students must be able to freely exchange ideas. They fear being sued for what they say in the classroom or what they write in journals. The project will grind to a halt. And we quote from various academics. Now, all the academics that we quote from, Barent and etc., Robert Post in 2012 article, we've given that to you in a bundle of authorities which we trust your ladyship has. So I'm not going to turn to them, but we ask that in time, as your ladyship retires to consider the judgment, your ladyship will have regard to those authorities. So we explain the issues in paragraph 17 and 18, and we explain what the issues are, bearing in mind that your ladyship must accept that the plaintiffs in this case have come to court in the defamation with an improper motive. That being so, is it not an abuse? And we say in paragraph 19.1, the slap plea. This defense argues the law prohibits as an abuse of process defamation claims brought for the sole purpose of silencing speech and which do not allege falsity, patrimonial loss, and the possibility of recovering that loss. The slap plea contends that the mining company is motivated by the ulterior purpose of silencing the defendants and others and have not pleaded falsity, loss, or the ability to recover. That is what the slap plea is about. And what Mr. Hodis's team say, that slap plea has no place in South African law. And we support the Mr. Budlander, the two Mr. Budlanders and Kazi, to the effect that that is just wrong in terms of South African common law, or as developed common law, if not included in the common law, then by virtue of development. We explain what academic freedom is in paragraph 23 and 24, and we explain what it is. And in 25, we explain the two phases, institutional and individual. And Mr. Duval seemed to accept that, and he accepted the Justice Frankfurter quote from the US Supreme Court as having some bearing on our case. But we submit that in our case, it isn't logical to exclude the institutional freedom, bearing in mind what it is that UCT does, and that it invited the activists to come and give a lecture as part of this new way of thinking or the development of new knowledge in a course. So the institutional, let's call it basis, as we've set out, or two faces as we've set out in paragraph 25, both play a role, both as far as the institution and as far as the individual is concerned. And so 27, where we talk about the institution, we find it hard to understand how the institutional basis or institutional face of academic freedom isn't implicated in this case. And similarly with the individual right of academic students to teach, research, and to learn. An activist may well not be somebody who's employed and gets a salary from a university. That certainly doesn't mean, as night follows day, that they aren't covered by the Academic Freedom Project. We submit that any person, and we include yourself, my lady, myself, Mr. Duval, who goes to a university and he or she talks about what's going on in the courts, what's going on in the, let's say your ladyship has an interest in, let's say, gender-based violence, what you see in the courts, what you sit on criminal appeals on a Friday, and UWC invite you to come and give a lecture on that topic of what happens in the courts on Fridays in criminal appeals. And your ladyship goes to the course and says certain things. How could it ever be suggested, with respect, that your ladyship's lecture to the law students at UWC isn't covered by academic freedom merely because you're being paid by the Department of Justice and not by UWC? We would submit that type of thinking is narrow, it's inappropriate, and it has no place in the type of society that we belong to and we want to belong to. And we say that sometimes there could be some conflict between the two when a professor objects to limits placed on his research, but these issues do not arise here. So why, and then the question is in paragraph 30 and we follow, why do we protect academic freedom? Why is it that it must mean something different from the ordinary protection of speech? Is there something special about academic freedom that takes it out of the ordinary when an activist stands on a soapbox in Adley Street rather than at UCT? And we submit that the academic answers and the judicial answers are to be found in paragraphs 30 all the way through to page, sorry, my lady, to page 13 in paragraph 41. And we would ask that the court accept those as why it is necessary to protect academic freedom in the way that has been described. So for example, in paragraph 33, we say that academic scholarship produces the most reliable knowledge available to us because the facts, methods, and reasoning are transparent, the scholars are selected and trained, and all results and approaches remain subject to criticism. Similarly with activists, they turn up at the lecture, they'll give their view about the compliance or otherwise, they will use words like exploitation, kill, and it can be analyzed, criticized, and debated in a way which is what we would call useful for the pursuit of the truth and further knowledge. Other types of speech, we say in section 34 or paragraph 34, is not subject to similar constraints. People are free under the general right to say what they please on the internet, social media, whatever it is, Facebook, Twitter, without putting their jobs at risk or seeking the prior approval of their peers. But academic speech is constrained by quality control and community approval. It is more valuable, and we give a long quote, and an important quote from Barrett as to why it is more valuable. So we say in paragraph 35, in conclusion, for these reasons, academics are uniquely able to produce new knowledge about many of the things we need most to understand, such as the drivers of poverty, inequality, climate change, cures for diseases, seeds for new technology, amongst hundreds of topics. While we can debate these issues at our kitchen table, those debates are unlikely to uncover new knowledge. And my lady, while I'm on this topic, it's interesting for me that I remember in the last few weeks seeing a Zapira cartoon where he described all these new professors coming out about their ideas about COVID, and every second person had an idea about why the COVID-19 has become what it is and what it's doing to society. So there's this kitchen professor. They've lost their job as a retailer somewhere, so now they become a kitchen professor. But that speech perhaps should be protected. But more important, when somebody at a university, whichever university, anywhere in the world, comes along with theories about whatever they may be, whether the COVID-19 was man-made or was comes from nature, all of these issues need to be debated, but so much more when it comes to within the academic environment. So while we say in paragraph 36, while all people have the right to speak about mining on the West Coast, academics are particularly suited to finding the truth about whether that mining is economically valuable, ecologically disastrous, whether it amounted to responsible extraction or negligent exploitation. And we explained the pandemic issue that I've just spoken about. If the academic project is distorted by government or private influence that seeks to silence popular ideas, we all suffer. And it applies to your ladyship's good example of HIV this morning. And so we say in paragraph 38, as Post argues, and this is our argument and we borrow from Post, it is not intended to protect professors, students, or universities. It exists to protect the academic project of advancing knowledge. That project can only be protected if independent academics can operate inside independent institutions, etc. And we talk about history from the Middle Ages to apartheid, teaches that governments and private entities will seek to interfere in universities for their own ends, and when they do, the search for truth suffers. And then that debate about the South African academics point. So that's why academic freedom is important. Then we say in the next chapter, under chapter 4 of our heads, which starts on paragraph 42, this part first explains how defamation suits and the threat of these suits. So it undermines academic freedom. It then identifies that those aspects are relevant in this matter. Now let me just say, it's not just this suit or any defamation suit that is relevant. It's any defamation suit or the threat of defamation suits that's relevant. So if this suit can go ahead, and let's call it bankrupt the Riddell 3, other similarly placed plaintiffs or governments will know that they can bring these suits, and the defendants and universities or other learning institutions will be wary, they'll be chilled to invite the kinds of debates from activists, from practitioners, from leaders of the ecological society in the West Coast or wherever they come from. So there needs to be a connection between the academia and the public in this way. So we say that the risk of defamation poses multiple risks that are particular to academic freedom. In paragraph 44, we cite from Gudger, The Trials of Academe, 2009 book, and we've given you the paragraphs in our bundle. But in contrast to most walks of life, speech and intellectual exchange are at the core of academic life. Proposing and challenging ideas and disseminating the results of research and learning are what colleges and universities are all about. Defamation suits cut to the very heart of that project, because the job of academics and scholars is to speak freely, challenge orthodoxy, and that's important, Marie. There needs to be a challenge to what is out there and seek to promote knowledge. Secondly, academics are particularly vulnerable to defamation suits because they have limited resources. So we know that your ladyship can take judicial notice of it. And it's stated in the textbook in any event. In Underwater was assaulted, the two academics sought you. Mr. Deval has given you an interesting description of the what happened with the case. And we don't need to say anything further. It's a 1994 case, and we agree with him as to his description, but where we disagree with him is to how it applies in our case. We say that for all the reasons that I've articulated, it's certainly, the types of thinking certainly cover our case. And in 48, even when academics want to stand by their work, universities or publishers, and this is the important institutional point, universities or publishers who may share the liability will either be cautious to publish, that might elicit a defamation suit, or withdraw any work that attracts such a suit. So this is the institutional point. It's not just about the individual professor or the individual activist who may be chilled, but the institution itself may be chilled by the possibility of a defamation suit because of the liability that they may attract by publishing. Paragraph 49, the third point is that defamation suits undermine the whole principle behind academic freedom, etc. In an academic context, disputes, as one judge has put it, and we give the citation in footnote 29, that's the Undervalde, note 26, plaintiffs cannot simply by filing suit and crying character assassination silence those who hold divergent views, no matter how adverse those views may be to plaintiffs' interests. Scientific controversies must be settled by the methods of science rather than methods of litigation. And we emphasize that. More papers, more discussion, better data, more satisfactory models, not larger awards of damages, marks the path towards superior understanding of the world around us. And we would say that type of statement or that type of thinking applies a fortiori to our case, and the particular facts about the environmental degradation to poor black communities in the various coasts of South Africa. Fourth, it is not ordinarily a requirement for plaintiff to prove that a defamatory statement is false. Instead, the onus is put on the defendant to establish truth, or truth and the public interest as a defense. In the context of academic speech, we say that that's our submission. This poses a particular difficulty. Meaningful academic speech by its nature seeks to establish new truths. And we emphasize not old truth, not repeat old truth. We live at academic speech lives at the boundary between fact and comment. That's what academic speech does. Lives at the boundary between fact and comment, and it seeks to establish new truths, not repeat old truths. And then there's the reference, as Mr. Duval explained, about between Dr. Singh and the British Chiropractic Society, and we give the example. He doesn't seem to have any difficulty with the notion of where it fits in. So we summarized in the last chapter the three reasons why it is that we say your ladyship should consider our arguments in the context of Mr. Hodis's exception to the first special plea. One, and this is paragraph 57, the speech at issue is undoubtedly academic speech. So that's why it's important. And we submit that for Mr. Duval to suggest otherwise, we say has no merit. We disagree fundamentally with the notion that this type of speech that was given if your ladyship has regard to those paragraphs in the founding affidavit, in particular paragraph 57 in the amicus's application, it clearly was academic speech. It was made at a lecture as part of the summer school. The lecture was arranged for highly experienced academics. In the last sentence, it was arranged using specific research funds, including a grant from the National Research Foundation entitled Race and the Making of the Environmental Public. And we submit that to suggest, as Mr. Duval says, that was not academic speech, as I've made the point 2 minutes ago, that's without foundation. Secondly, paragraph 59, the suit itself will have a chilling effect. Again, Mr. Duval says that's not so. How can it not be so that when UCT decide who to invite as part of an interdisciplinary course, and concerning the trade-off in environmental concerns, they don't take into account the possibility of a suit when it's not a professor or lecturer employed as an academic who comes along. So UCT would certainly, and if I read, and I'll read again from the founding papers, the goal was to explore in a classroom situation and with a range of actors the emergence of Black-led environmental movements. And again, at the last sentence, the course affirmed the value of different approaches to pedagogy, enabling audiences to engage with different experiences, perceptions, and evidence, and having done so to better understand emerging alternative approaches to environmentalism in the public sphere. Now, if UCT had to think, well, if we invite professors and lecturers, but not activists, not practitioners, we'll be protected under the guise of academic freedom, that would be chilling and deny the whole project and the type of project that the course was aimed at gearing towards. So secondly, we disagree fundamentally when Mr. Duval says it would not, this suit will not have a chilling effect. Of course it will. UCT will think twice about inviting activists next time if they know that activists can get sued for the types of activities that took place. So we emphasize those paragraphs from 59 through to 62 on this aspect. Third, and he suggests that there's this whole debate about questions of trading corporations. And from the perspective, we say that from a perspective of academic speech, it is justifiable to treat trading corporations differently. But your ladyship put to, I think it was Mr. Budlander, that there's this balancing exercise that needs to be undertaken. And we would not disagree with your ladyship. In fact, we would agree entirely that when your ladyship considers the whole notion of a slap suit by a corporation and the kinds of issues at stake, and as Mr. Budlander very neatly put it, they're suing for 14 million rand in respect of, I think it's 6 people who have nothing. You balance. They don't claim to have any reputational damage, and we know the case will end up in the Constitutional Court on the second special plea. But in this context, in the context of the first special plea, in the slap suit, we would submit that the balancing that it needs to be struck as to the, let's call it the plaintiff section 34 rights, in the context of how they've pleaded and what must be accepted that they've come to court on an ulterior purpose, needs to be balanced against the kinds of rights that we seek to assert and the advancement of knowledge in the ways that we propose. Normally, my lady, I would say to Mr. Bishop or Ms. Peterson with me, do they have anything to add? But I'd like to think that I've covered the ground, and Mr. Bishop can perhaps tell me by way of WhatsApp. So, my lady, those are my submissions. I don't believe I have anything else to add. I do want to say, he says to me it's all good by WhatsApp. What I do want to add is, of course, that the other parties are correct, that there's no issue of costs, and the authority for that is Hoffman versus South African Airways, where there were various amici that came into the court and to assist the court in deciding whether Mr. Hoffman's claim about unfair discrimination not being offered a position as an air crew steward no longer as 2001. And what the Constitutional Court said in Hoffman versus South African Airways, I'll give you the court the reference, 2001, volume 1, SA, page 1, Constitutional Court at page 63, that when it comes to amici, generally speaking, there should be no costs either way. And we don't ask for costs, and similarly, nobody is asking for costs against us, but we do submit that this court should take into account our concerns when it comes to academic freedom, as it pleases the court.
Thank you very much, Advocate Katz. I think the amici do have different angles, and the court appreciates the involvement of the amici in this matter. I think it is very important.
Thank you,
Ms. Pasha.
So we proceed. What is the
Absolutely.
position, Pasha, with tomorrow?
My lady, well, I'm of the view that our submissions are in line with our heads, and that at this stage, seeing as most of the issues have really been ventilated, that we could possibly proceed and still finish maybe 5+3 or so, if possible. So I think
No pressure on you. I'm happy to come back tomorrow. But if you're ready, I'm happy to continue.
I think we should proceed, my lady.
Yes, sure. Right, I have your heads in front of me. Is there any other document that you would like me to have in front of me, except your heads?
My lady, at some point I will refer to the exception itself and the special pleas that were taken. Yes. But I can quote directly from the heads, and that shouldn't be an issue.
Yeah, I have it in front of me as well, the actual pleas. Thank you very much. You may then proceed.
Right, my lady. Let me just start off by saying, my lady, there has been an issue that was raised by Mr. Horace when he started. And the issue was that it seemed that it wasn't quite clear what CALSA's position was in this matter, in particular, in the second special plea. But let me just start off by clearing out why CALS is involved in this matter and really what it is we seek to assist the court with. So CALS is admitted as amicus in the Radel matter specifically and not Lamini and the others. And the reason CALS was admitted in the main case, that is because it seeks to advance submissions to the court to aid the court in understanding SLAP suits specifically. And at that stage, of course, the special pleas had not been raised. So that was a very unique position that CALS was coming to aid the court with. So those were issues of novelty. But my lady will note that, of course, because of the exception, that position has now been overtaken by events, and we now have to delve into this issue before we even go to trial with it. So this is really what we want to deal with in this matter. We limit our submissions in this regard to what we've said in our heads, which is we really just want to aid the court in understanding what SLAP suits are and how they differ from the other litigation proceedings that are before this court. So in the primary issue here, my lady, and this is our primary stance and it's a preliminary point I want to make, is that we differ with the other parties, particularly the respondents. Although we support them in this application, we differ with them to the extent that they take the view that a SLAP suit is not necessarily all that different from an abuse of court process, or that the two somehow can be merged. CALS differs fundamentally on this principle. We say SLAP suits are not defamation cases. They're not an abuse of process. The requirements are different. I would say in our law, but we don't have the common law in this respect. And if we did, we would submit that would have to be the case. But from the jurisprudence, my lady, that has been put before you, a plethora of it, mind you, from international foreign law specifically, you will note that the SLAP suits as they're defined there have two views really that have to be taken into account. The first is the ulterior purpose, and also whether the case is meritless ultimately. So this is the view that CALS takes. CALS is of the view that a SLAP suit is not an abuse of process, and that an abuse of process, of course, is regulated in our law by the Vexatious Proceedings Act and by common law as it stands. Where the common law therefore needs to be developed further to accommodate a SLAP suit, or to develop common law as suggested by the defendants, is not something that CALS really wishes to engage in, because we don't in our heads deal with, nor would we deal with it in a trial where the common law actually is sufficient as it stands to deal with the contentions made by the defendant. But of course, before we go any further, my lady, and I'm about to move into my submissions, which is why I said we will be fairly quick. This is an exception in nature. And before we go anywhere, the court must accept that the pleadings that have been put before it are correct. And that is the premise where we start. So if we are to accept that what the defendants, or respondents rather, in this case, have said to be correct, then we move from that premise. And then we need to look at what it is that the plaintiffs and applicants in this case are saying is excipiable when it comes to SLAP suits. So CALS wants to make two primary submissions here, my lady. Firstly, we say in terms of the common law, the proceedings of defamation proceedings, such as the present one, are amounting to SLAP suit, and we want the law to recognize that. But if the courts are not with us, then we are suggesting that the common law should be developed to recognize that aspect, the aspect of the existence of SLAP suit, and that it should be recognized in our law. Of course, we're not suggesting that the courts must move into the shoes of the legislature, but I'll deal with that later, my lady. So this is what we want to deal with. And my lady, then if we accept this primary position, which is the primary position that CALS takes, Then we define, my lady, in our heads what we believe is a SLAPP suit. And I may not be able to go into it in further detail or define it as eloquently as my colleague, Mr. Butlander, has. But my lady, the primary point is this. If you're dealing with a SLAPP suit, you're dealing with a meritless case, which amounts to discouraging parties from pursuing their rights. And that's what we say the plaintiffs have done in this case. And we say the court has actually got to accept this primary view, that the plaintiffs have done this because the defendants have said so in their pleadings. So we're moving from that premise that the plaintiffs have instituted a meritless case, which is intended for no other purpose but to discourage the public, or in fact the defendants themselves in particular, from pursuing their rights, specifically their rights to freedom of expression. My lady, then we want to assist the court by distinguishing a SLAPP suit from other types of litigation. And we do this in 4 ways. We say, first of all, the definition of a SLAPP suit as we see it from foreign jurisprudence tells you that there's 2 aspects to it. And I've already alluded to what those aspects are. The aspects are fact that it's meritless case, and then it's been instituted purely for ulterior purposes. That is the first thing that distinguishes a SLAPP suit, we say, from other cases. Because as you would know, this is not a requirement that's required in vexatious proceedings. It's not a requirement in what we currently understand to be an abuse of court process, either in terms of the act or in terms of common law. In our view, that may or may not be necessary, my lady, but what we are acknowledging here is that on that premises alone, SLAPP suits should not be equated to an abuse of court process. Of course, the second element here, my lady, is that SLAPP suits by nature target a certain group of people. They commonly target activists, they will target human rights defenders, journalists, human rights lawyers. The list is endless, my lady. But we know this group of people that is generally targeted in these type of cases. And it's important that we acknowledge this. Because if we don't acknowledge the fact that SLAPP suits generally are intended to deal with a specific group of people, we will find ourselves wanting to limit expression of people endlessly, or we will find ourselves wanting to limit the right to court processes by suggesting that, well, you know what, your purposes you might have an ulterior motive here, so therefore you shouldn't have your day in court, or your day in court should be limited. So I think we have to get to a point where once we establish that there is a SLAPP suit, we put it in its own box so that we don't conflate issues. I think this is where we differ, my lady, with the main parties in this issue, because it seems where we are standing that there has been some conflating of issues here between what a SLAPP suit and an abuse of process may be. My lady, thirdly, in terms of where we sit in South African law and why we want to submit that the court acknowledge SLAPP suits on its own standing, is that to this day, we only have one case that is a reported case in the law reports, which is the Wapex case that specifically deals with SLAPP suits. And that case is, of course, important here in these proceedings. And we've already mentioned it in our heads of argument, my lady. The Wapex case, my lady, shows us 2 things. It shows us that, first, SLAPP suits are not identical to vexatious litigation. That's what we established from that case, my lady, and we refer that to our heads of argument. We also see from that case that SLAPP suits have not been disallowed by our courts, and this is an important element. We do not have the common law, the precedent that's been said that we preclude this court in particular to develop the law any further in this respect. because that only judgment, that only one judgment is not binding on this court, and this court does not necessarily, of course, have to follow it. But because it doesn't necessarily even have to follow it, this court can decide that it wants to develop the common law. So this is not the same as what the plaintiffs have been arguing in the Mapanga case, which is to say it's binding on the court, and we agree that Mapanga is binding on the court. So my lady, I just want to read a paragraph from the WAPEX case, because as I said, it's the only piece of common law that we have that specifically deals with this issue, and it bears mention in this court. I will read a quick paragraph, my lady. I can refer you to it in my heads of argument. If you just give me a second, I'll tell you what page you can find it from. My lady will see it's at the bottom of page 35. We start referring to it there.
Thank you. Yes.
Yes, my lady. So let me just go back to. So the court alluded to this in that case, my lady. The defendants also made reference to the belligerent tone of the plaintiff's attorney's letter, which were calculated to intimidate and create enmity. There's such justification for this view taken by the defendants. The general weak merits of the case became obvious during the trial. My lady, I'm not going to read the whole paragraph, it's there. And I mention this, my lady, because we want to say in this case that it is important that the issues of slap suits are ventilated properly in trial so that the merits can be established. And this is the principles that go to exceptions as a whole, my lady. And we refer you to this also in our heads of argument. We say in our heads of argument that should this exception be upheld, this issue will not even be ventilated. But what is the worst case scenario, my lady, if the exceptions is not upheld, in particular to the first special plea, the second part of it, my lady, and I will come to this point. So we refer to this, my lady, in our heads of argument. You will see from page 17. If you go to page 17, you will see, my lady, we explain there what the implications of an exception are. And we say to the court that if this exception is upheld, that this issue will not receive the attention from the court that it requires. And then I want to move on, my lady, from that case. But before I do, let me just mention that because, my lady, this is the only case we have to rely on, we want to suggest that the court can and is not precluded from developing the common law in this regard if the court believes it should. And we say the court would possibly want to develop the common law in regards to the slap suit specifically because there's a gap. I then want to deal with the exception in detail, my lady. The exception you will see that has been raised by the plaintiffs starts at, in particular, paragraph 1 and 2 of the exception. I've kind of just lost it. Excuse me, my lady. This device tends to keep running away from me.
No problem.
Ah, yes, I found it. My apologies. Now, you will see the way the exception is structured, in particular to the first special plea.
Yes.
And in the heads of argument as well of the plaintiffs, they go into length as to what it is that they actually found to be wrong with how the abuse of process has been pleaded. They go into detail with explaining what is wrong with the second special plea, although we're not dealing with that because we've received an all-round concession on that aspect. But my lady, you will see specifically, if you go to page 2 of the exception, at paragraph 1.1 and paragraph 1.2, what the applicants say there, my lady, is that the special plea is not in line with the Vexatious Proceedings Act, and it's not in line with common law. But my lady, if you read this further, you will realize that what really the applicants are complaining about here is an abuse of process. They say nothing about a slap suit, my lady. The only thing that we see that comes about a slap suit is much later on, and it's specifically with relation to the complex nature of slap suits, which comes in the heads of argument. My lady, I want to submit to you that that has never been a reason in law to uphold an exception. That does not make the special plea, particular in regards to the slap suit, executable at all. Why would it? The defendants, to the extent that it can be said in the pleadings as a whole, that all the necessary amendments have been made. And that is our submission, that all the necessary amendments have been made, which are required to sustain a defense of a slap suit as it exists in foreign law and possibly will exist in our law if the court develops it. Those amendments have been made. And if we separate the issues, my lady, and we don't conflate slap suits with an abuse of process, then we see that there is nothing exceptional about that particular special plea. And my lady, I want to emphasize that we must make this separation, because even if you go, my lady, to the defense's notice of intention to amend, which is where you will see the first special plea that I speak about, and we say this in our heads, is that the special plea is structured in a way where you can clearly see at page 1 there that it's an abuse of process and strategic litigation against public participation. We suggest on the simple reading of this, and if we apply the rules to interpretation of statutes even to this, these are two separate issues. It seems for some reason, my lady, that the respondents are of the view that it's one. But how we read it, my lady, and that it remains our stance, is that a slap suit is not an abuse of process. And if the two things are, if the two positions in law are different, and the one is pleaded appropriately, there's no reason to uphold the exception, especially in relation to the slap, because there's absolutely nothing wrong with it. It cannot be said on these papers, my lady, it cannot be said that it wasn't properly pleaded. That would not be correct in law. And if, my lady, we accept that exception then cannot be upheld, then it remains that this issue must be argued at trial, which is what would happen, my lady, in the ordinary course had the exception not been raised. And I want to, for a moment, deal with this, because this is one of the things that we say it's an example of what amounts to a slap suit. When you have a big corporation that has all the money and has all the powers and has probably the best legal teams, my lady. They can nitpick at every angle in litigation, not because they shouldn't, but purely because for them, it works. It serves them financially to drag out litigation and to take every point in law that one can possibly take. But the same cannot be said for the defendants, even if they were not being represented pro bono. But even when they are, my lady, it doesn't stand that just because people have pro bono counsel that litigation must be dragged out endlessly. And this is really one of the points, and this is important in this regard, because if these exceptions are upheld, my lady, the issue of whether this is or is not a slap, whether this litigation actually is motivated by ulterior purposes, will never be ventilated. It will die here. It will never see light of day. And we submit, my lady, that that would not be correct, and that would not aid this court or aid our law in any way. My lady, then it leaves us with the second question. If we have answered the first question, which is whether these proceedings can be seen to be a slap suit, which we submit they can be. The question is, if in any event, if the court is not with us and the court does not believe that that would be the correct position in law, can this court then develop common law appropriately to support the position that is proposed? We submit by the defendants in the alternative, but largely by CALS, because we are the ones that are submitting that slap suits must be viewed on their own merits and their own stands, and that they shouldn't be conflated with an abuse of process. My lady, we've referred you to the case law, and we submit as the Center for Applied Legal Studies that the case of Mapanga does not preclude this court in any way, shape, or form from developing the common law in relation to slap suits in particular. Mapanga dealt with very different facts, my lady, and we've alluded to that in our heads of argument. The case of Mapanga, my lady, was not dealing with a slap suit at all. And even if we accept, and we do accept that in terms of the principles of precedent, this court is bound by Mapanga. But what we do say as the Center for Applied Legal Studies, that Mapanga does not preclude this court from developing the law in relation to slap suits at all. We have made the submission that the only court that has dealt with slap suits in our law was the WAPEX decision. And that decision also wouldn't bar this court in any way, shape, or form. In any event, if the court did want to take that decision into consideration, the considerations would be favorable, because that court does acknowledge the existence of slap suits and it doesn't preclude them from being applied in our law. And it definitely supports our contentions because it separates the idea of vexatious proceedings from slap suits. So my lady, Mapanga wouldn't stop you or your court from developing the law in relation to the recognition of a slap suit, if my lady was inclined to do so. My lady, we want to submit that apart from the fact that slap suits are complicated, and we concede to this, so that element is not contentious. The plaintiffs, rather applicants in this matter, have not given you any reason why you wouldn't be able to develop common law, even if it was correct to say the law as it exists does not cater for slap suits. But we also want to suggest, my lady, that in terms of Section 39, as 39.2 specifically, my lady would be well placed to develop the common law in this matter. We also want to suggest to you, my lady, that nobody, and in fact, my lady, this stands undisputed. Nobody has said, and in particular, not the applicants, that the Vexatious Proceedings Act as it stands sufficiently deals with slap suits. And because that has not been said, my lady, we submit that the principles of subsidiary don't exist in this matter. But we have also referred, my lady, to the correct case law. For example, my vote, my lady, which is a decision from the Constitutional Court, which shows that even if the principle did exist, the principle has not been developed to finality by that court, and that different interpretations can apply. So my lady is not precluded, and certainly the defendants wouldn't have been precluded from relying on the Constitution directly and asking for a development of common law in this respect. My lady, we submit that because there is a gap in the law. There is, in fact, a mandate on this court in terms of the Constitution and the cases we've referred to develop the common law appropriately. We note, my lady, that the legislature has not done so, and that there are complexities. But with respect, my lady, that has never been a reason in our history, and certainly in our law, for the courts to shy away from a task that, based on the facts of this case on their own, demonstrate that there's a definite need from the courts to intervene. We cannot leave it to the legislature unabated to, at some point one day, decide to come up with legislation that we don't know that they will or will not come up with. The issues are before court now. The parties require a solution, and it's up to this court to do something about it. And there is no law, we submit, my lady, that we are aware of, that in fact has been put before you by any of the parties, that suggests that you must wait for the legislature in order to deal with issues of SLAP suits, because the legislature has not done so yet. My lady, if there's nothing in particular you would like me to address, the rest of the submissions we really want to make in this regard already appear in our heads.
Yes.
Our issues were fairly narrow in this regard, and I would like to suggest that our submissions were useful to this court, and that they were novel, and that they were different from the submissions made by the other parties. My lady, I don't want to go into the issue of costs. I think we can all agree that because we are the amicus that was aiding this court in novel submissions, which were useful, and because we've received a concession from the parties that they wouldn't be seeking costs in any event, I wouldn't want to take up the court's time in dealing with that issue in particular. I would only like to address the court on specific issues if the court has so, and to find out from my colleague if there's anything they believe I should address in particular.
No, I have no further issues that I'd like to raise. I think your heads are quite thorough. And you have, in fact, competently argued the issue surrounding the SLAP suit. The novel issue of the SLAP suit in South Africa. Is there anything else you would like to add? Can you just check with your colleagues?
Yes, my lady. I don't see any communication from either my colleague or my attorney, so I would like to suggest that is the end of our submissions.
Thank you very much. I think that will then be the end of our sitting today. We shall then roll over this matter until tomorrow for the reply. I think that is then all that needs to be done. But if there are other parties who would like to raise anything else before the reply, they're welcome to do so. And you can just convey that to them. So we will then resume at 10 o'clock tomorrow morning. Thank you very much. We shall then adjourn.
As a copy, please.
Thank you.
Yes, immediately. Okay, would you